Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends, and thank you so much for coming to spend part of your day with me. Today is Tuesday, February 18th of 2025, and today we're going back to Dedham. Going back to Dedham, Massachusetts, Norfolk Superior Court, to the courtroom of Justice Beverly Cannone for the pretrial motion hearing on the re-persecution of Karen Read, which is allegedly scheduled to start on April Fool's Day. Believe it or not, it's kind of fitting. I was hoping to get the docket numbers, the papers that were filed on Friday, allegedly, or they were actually entered into the court system on Friday. They were not apparently scanned into the court system, into mass courts on Friday. So, long weekend and all. And I wanted to be able to go over them with you this morning, but so far they're not available. It's the opposition to the Commonwealth. Let me see what it's the motion for sanctions that the Commonwealth made, which I'm still not really exactly sure what the grounds are for them asking for sanctions against the defense. I've heard, rumor and speculation, but I haven't actually seen the papers. And also they filed the Commonwealth, that is, filed an opposition to couple of the motions. Let me just see if I can get back on the system. If anybody has docket numbers 501 to 505 and they want to email them to me, that would be freaking awesome. It's fanbase at mlittlelaw.com, fanbase at mlittlelaw.com. But my sources were not able to access them this morning, nor over the weekend, and not on Friday. So in true Commonwealth fashion, they got them into the docket so that the press would grab a hold of it. Although not knowing exactly what the contents are, it's kind of hard to figure out why they want sanctions. So let's see. So this is interesting. There's something else that was filed. A couple things filed this morning. Look at this. All right, so now we're up to docket 510. So what we need is dockets number 501 to 510. Here are the things that we cannot get our hands on because, we know everyone likes their weekends in this courtroom, right? All right, so here's what's missing. The Commonwealth's pretrial conference report, Commonwealth's response to defendant's motion to compel discovery, and that's the motion to compel that we looked at where the defense is looking for all of the information on the Sallyport video, each piece of video, when it was turned over, how they got it, where the metadata is, all of the information with regard to communications between Bukhenik and Chris Albert and all law enforcement and all witnesses in this case. So, and a lot of other things were in that motion as well. There's also a Commonwealth's opposition to the defendant's motion to reconsider reciprocal discovery. That's the motion that the defense made. And they said in their motion, we shouldn't have to turn over our impeachment evidence on the witnesses for the Commonwealth until after they testify. Because what had happened was in the last trial, it seemed that all the Commonwealth witnesses were prepped with that impeachment testimony or impeachment material before they testified, and therefore they were able to head it off at the pass. For example, things like Proctor's text messages, the video that showed the nephew and the steak tips incident. We went over that and how he was maybe prepped to say that it was a different incident. And they gave other examples in that motion that are escaping me right now. Take steak tips versus takeout. Court doesn't start until 11, so it's not really late. I started early. I started early because I was hoping we would have all these documents to go over before. Oh, yes, Jen McCabe being at Lank's house. Remember, they turned that over to the Commonwealth, and then Jen McCabe was able to fabricate a story about why she went over to Michael Lank's house, although she didn't even bring up the fact that she went to Michael Lank's house on the day up. Was it the day up? Was it the 29th or the 30th that she went there with Kerry Roberts, allegedly because Kerry Roberts' child was friends with the Lank child? That's great. Thank you very much, Cam's Graham, for reminding me of that. There's also the Commonwealth's motion to impose sanctions. That's 504. And then we have Karen's opposition to the Commonwealth's motion to exclude ARCA. That's another motion we should hear about today. Then we have a Commonwealth's response to defendants' motion to compel the production of a forensically sound copy of all of the video surveillance from the Sallyport. You know, they want the metadata and everything on that because, you know, how about, foundation, best evidence rule, make sure it wasn't tampered with. Crazy. And then we have, so there's an opposition to that. I don't know how they could oppose that really, but it'll be interesting to hear the arguments today, not knowing exactly what the arguments are going to be. Then there's the Commonwealth's opposition to the defendant's motion to exclude testimony of James Crosby, the dog behaviorist that they're trying to introduce as an expert. We did go over the original motion on that and why, in the defense's opinion, James Crosby should not be permitted to testify about the injuries to John O'Keefe's right arm because he's not a medical doctor. And they quoted Judge Cannoni and her exact speech from the last trial where she said that Dr. Wolf, I think, Dr. Rentschler or Dr. Wolf, one of the crash daddies was not allowed to opine about the injuries to John O'Keefe's right arm because he was not, in fact, a medical doctor. Well, neither is James Crosby a medical doctor. He is a dog behaviorist with a PhD in some sort of veterinary. He's not a vet. He's not a doctor. He's a dog behaviorist. In fact, his website or company is called Canine Aggression. So he may be a witness in, he may be a proper expert witness in a different case, but not with regard to opining as to the cause of injuries based on the judge's own ruling during the first persecution of Karen Reed. And then we also have an affidavit in support of their opposition to the motion on James Crosby. And then, this is interesting. There's an affidavit of attorney Mark Diller, M-A-R-C, Diller, on behalf of the O'Keefe family in response to defendants' Rules 14 and 17 motion for a court order authorizing the defense to access the Lexus and the Traverse and to the driveway at 1 Meadows Avenue in Canton. So I'm not sure who this attorney is. Does anybody know who this attorney is? Defense has made a motion for access to the driveway at 1 Meadows, Karen's Lexus, and John's Traverse so that they can recreate the incident in the driveway where Karen backed out of the garage and into the Traverse so that they can prove that that's how her taillight was cracked. So I don't know who Mark Diller is, but I can look him up. Look at this. Look at you guys coming in hot this morning. Tracy Walker gifting 20 memberships. Thank you, Tracy. To everyone who was randomly chosen by YouTube to receive a free membership from Tracy. Thank you so much, Tracy. You've been gifting memberships like crazy. You've been so very kind and generous to this channel, and I really, really appreciate you. Lori Life 360 for the win is here this morning. She's been here for 10 months and says, I can't wait. Can't wait. My favorite place to be in the AM. Thanks, Lori. Holly Johnson's a new member. And Karen Gelsman's a new member. Welcome. Buzzing for Truth is here and has been here for 13 months. Thanks for all the good info. You're welcome. Thanks, you guys, for being interested in this case and for wanting justice and for being here with me so often. Nancy Joe, thank you so much for the 20. Do you think Judge Cunningham would try to keep Bederow out because he represented or represents Turtle Boy? There are ways here. Any potential conflict can be waived by both of the clients that you represent. And I would imagine that Mark Bederow has received waivers from both Karen and Aiden. I'm sure that's what you are referring to, whether or not she can exclude him because of a conflict. But if the clients waive the conflict, then there is no conflict. Then she should have no reason to exclude him unless she's going to say the table's not big enough. There's no room for him. I don't know. It's going to be interesting, though. I've never seen a judge oppose a pro hoc vice application for an attorney to come in from out of state. But remember how she questioned that application on Alessi? And I've never seen that either. She said, well, what kind of law does he practice? And why do you need him? Why do you need him? Why do you need somebody outside of Massachusetts? And Dave Giannetti said, well, no, because he's a great criminal defense lawyer also. And, he's got a lot of specialized knowledge. And she did let him in sort of begrudgingly. So it'll be interesting. Tracy gifted another 10 memberships. Thank you, Tracy. This one predated the 20. So thank you, Tracy. You're amazing. Barry Raven, the motion to deny the defense examining the driveway. I have the motion. I don't have the opposition. Is the opposition out there? Hang on. What I need is the opposition. We went over the motion last week, the day that it came out. And so I don't have it, but I can take a look. I don't know if that's what you're talking about, Emma, but thank you, Emma. Emma's here from Ireland, everyone. Emma's here from Ireland. Fairy Raven. Good morning to Australia. Defects in flawed methodology. Thanks for tuning in. Showtime. Appreciates me and my expertise as always. Well, thank you so very much for being here because I appreciate you just as much, if not more than you appreciate me. On Top is here and always on top of the super stickers. Thank you so much. Today's your birthday, AJ's Beard. Happy birthday. Happy birthday to AJ's Beard, everyone. My wish is for some pro Karen Reed rulings. Go Buffs. Go Buffs. Proud alum, University of Colorado at Boulder. If you know, you know. Deion Sanders is here, and it's going to be a great year. Another great year. Thanks, Mark McKay, for hanging out for 5 months. Thanks for making such great videos, Melanie. Oh, thank you so very much. Thank you. Appreciate you. Mrs. Bucket, which I have found is now is pronounced Mrs. Bouquet. Mrs. Bouquet is here from across the pond. Thank you so very much for joining us this morning, my dear. Kirsten, thank you. If the O'Keefes want justice, allow the testing. Look, do you think anybody really wants to get at the truth here? We talked about this yesterday. When we went over the entire extended version of the 1 hour and 11-minute interview of Ted Daniel that he did of Karen Reed. And it was a great interview, I thought. Do they want to get at the truth, or are they just looking for a conviction? Because if they wanted to get to the truth, they would have called the ARCA experts because they had just as much access to them as Karen Reed's team did. Thank you. Poison Ivy, Mark Diller's website header, Diller Law, Boston personal injury. Oh, you know what? I think he is their attorney in the civil suit in the car accident case. I think he is. I think he's the plaintiff's lawyer for the O'Keefes in the case in which they are suing Karen Reed and the Waterfall and CF McCarthy's for wrongful death and other assorted emotional injuries for this alleged car accident, which in my opinion did not happen. Because hey, where's the crash report? Oh, that's right, there isn't one. There's no car accident. There's no motor vehicle accident report in this case. Good luck with the civil suit. Stranger things have happened. Good morning, Patty. Thank you for your super sticker. Boston Terrier says there's room for Bederow. He's pint-sized, but he's a gigantic brain. I'm only 5 feet tall myself. That's funny. Thank you for your super chat. And also, Abe Enterland became a member. Welcome, welcome, welcome. And thank you again, Tracy, for gifting 30 memberships already this morning. So everyone pretty much should be a member. Well, look, there's 5,400 of you. This is just your reminder to smash the like button on your way in because, you know, it helps push the video out, helps the algorithm and all that stuff. And so, you know, if you want everyone to know about this case, let's get it out there. Thank you so much, Roberta Marshall, for your super chat, for thanking me. Today should be interesting, says not that Auntie Bev. And she is here for it too. We have a number of motions to go over today. How's everyone doing? How is everyone doing? O'Keefe family is fighting access to the driveway. He's the civil attorney. Yeah, he's the attorney, the plaintiff's attorney for their civil case. That one, I think that one's pending in it is pending in Plymouth County, I believe. And his name, I knew his name sounded familiar, and that was my original guess on that. So that is that. It's set for 11 o'clock. Who knows if they'll be on time? That is 13 minutes from now. Did you guys watch the SNL 50th on Sunday night? It was 3 hours long. It was fantastic. Tell me what your favorite skit was. My favorite thing, one of my favorite things about the 50th was that, first of all, I've been watching that show for my whole entire life. But second of all, the Volkswagen bus is coming back. That is so exciting. And they did a commercial with the Californians, which is one of my favorite skits from SNL. And it was the Californians introducing the new Volkswagen bus, which is coming back. And it's so exciting. Good morning, Little Master Red Velvet. Member for 8 months, been with you since day one of this trial. You inform us every day of the law, learning so much. Best channel on YouTube. Thank you so much. Thank you so much, Little Miss Red Velvet, for tuning in and for your super chat. And Alibi McCabe is here. A new member. Welcome, Alibi McCabe. You guys have the funniest usernames on YouTube, and you're also the funniest chat on YouTube. You're the snark tank, and it is quite competitive in there to be the funniest of the day. Fire on Acid is here. Can Bev overrule the O'Keefe's lawyer to test? I don't know what the opposition says, so I can't opine on that. They are filing an opposition to the motion on behalf of the O'Keefe family. Do they have standing to do that? I mean, I suppose they do because they live there, but I haven't seen the opposition, so I can't opine on that because I don't have the papers. Hello to Denmark. Lean Salverson, Lean, Ayin, I'm not sure if that's an I or an L, but Denmark is watching and has been watching for at least 5 months. Cookie Harris is here. Here we go. Love to the best community and to you. Love you so much. Thanks, Cookie Harris. Caroline became a new member. Welcome, welcome. Midnight Mike says, how many times will we hear Bev ask Brennan, do you want to object? Go Notre Dame women, #1. Fantastic, fantastic. Could be a long day. You might want to get yourself a big giant iced coffee or a cocktail. I don't know where you live or where you're watching from, but get a snack because it could be a long day. There's a lot of motions and it could be exciting. Oh, Alan's here. Okay, hang on. I wasn't sure if Alan was going to be there today. Hang on. Let me just rewind this a little tiny bit because Tom, CPU, and Boston Mike have some footage of them walking into the courthouse, which we always like to play because they let me. Sounds kind of loud. I mean, his audio is not that great right this second. It's cold. There's snow on the ground. There's Karen. And Esty. And is that David Yannetti? Was that Liza? Here's Alan Jackson. Alan Jackson and his beard are both here. And there's the Lessie.
All right.
Big crowd. Big crowd.
Oh, this should be a good one today, bro.
That's cool. Yay. I'm glad Karen had somebody helping her down the sidewalk because it looks really icy out there. It looks really icy out there. So the team is there. Karen is there. We're here for it. And I've got, let's see what we have. We have Court TV up and Law and Crime up. So we'll see who's got the best feed today with regard to sound, camera, and everything else. Trooper Pulse Pirouette says there isn't snow on the ground until Lally confirms it. Well done. Well done. Mrs. Bouquet, I don't know who Law Daddy is to you, but I did not see Mark Bederow, if that's what you're talking about. I don't think he needs to be there for this application. I did not see him. Did anybody else see him? Good morning, Doc 12. Thanks for the super chat. Does Karen's second trial have to be by jury, or can she elect a bench trial? She can elect a bench trial. She can elect a bench trial right before jury selection. We saw that in the Penny McGee case. And the Penny McGee case was tried by Judge Cannoni as a bench trial in the exact same courtroom. And Penny McGee was acquitted. And that was a crazy case. For those of you who didn't watch it, you should go back and watch that trial. It was only maybe a 3-day trial. We watched it together. Penny McGee is a woman who was on trial for manslaughter, facing 20 years in prison because her ex-husband, whom she had an argument with and may have shoved, dropped dead of a heart attack in the foyer of the home that they were both living in together. And she was on trial for manslaughter, even though he died of a heart attack combined with diabetes and a 90% occlusion in one of his carotid arteries. And other pre-existing heart conditions. He had had a stroke and etc. Judge Cannoni found her not guilty on all counts, and it was a great day. It was a great trial. And so Turtle Boy's interview with juror leaves me with a lot of questions, says Doc 12. Yes. Yes. Mark Bederow is a big proponent of bench trials. A lot of criminal defense attorneys are because, for example, in Penny McGee's case, it was Penny's choice to choose a bench trial, and she felt that perhaps the jury would be swayed by her daughter's testimony, Zuzi, who was estranged from her mother. She was a senior in high school at the time. Or the medical examiner's testimony, which was wild because the medical examiner looked at some guidelines and said, well, the guidelines here say that if two people are in an argument and one person dies, it can be ruled a homicide. I mean, it was just crazy. It was just crazy. You guys who watched it know. It was crazy. Leaves me with a lot of questions too. In my opinion, do I think Judge Cannoni is probably able to discern that John O'Keefe was not hit by a car? Yeah, I think she is, but it's always a risk. And to me, that's how simple this case is. John O'Keefe was not hit by a car. That's it. There's no injuries to support that. Taillight didn't start to be found until after Karen's car was seized, like she said in her interview to Ted Daniel, and that's the case. It's not that complicated. They didn't need to put 60-something witnesses on the Commonwealth. Kirsten, thanks for tuning in from Canada. Excellent interview. Knowing Karen's strength to fight injustice, no matter her outcome, says it all about her. Inspirational. I agree. I think Ted Daniel should get some props for that. I mean, he did get the interview of the year, let's face it. And the editing was fantastic. I don't know why they didn't air it on the station. They just put it up on YouTube, but they didn't ask me. Pierce says that she had a VW bus named Ruby. Great memories. Oh, that's awesome. That's awesome, Pierre. Love those VW buses. Arlene is here. Loves me, the cupcakes, and the mods. Thank you for being here, Arlene, for a whole year. For a whole year. Thank you. I'm just a girl in the world. Good morning. Good morning to you, too. Best chat on YouTube. You know it, girl. Thank you so much for your 10. Lady Tammy says, what do we think will be on Aiden's screen today? I don't know. Let's see. Camera's up. He did have RIP Clay Carney on his screen. He says that it's just his screensaver and he didn't realize that it was on camera, and he got a lot of agita for it. But the fan is back. Did everyone miss the fan? Did you guys miss the fan? I'm going to mute it until they start because chatter. Don't rely on the captions. They're often wrong, but I put them up because a lot of you have trouble hearing the sound. So, I'm here to help. So, Tammy, I don't know. Good question. We'll see. Attorney Wannabe, thanks for your 5. Good morning. Loved your coverage of the Ted Daniel interview. Thank you. Thank you. We had fun doing that yesterday. It was a fun time. Poison Ivy says it's disheartening to hear the jurors' interpretation of the first trial evidence and testimony. Praying for pro-Karen Read outcomes today. This could be any of us. What's so interesting, and I said this yesterday when we talked a bit about Ronnie, the jurors' takeaways from this trial, and he came and he did an interview with Aiden Carney, Turtle Boy, on Saturday night. He came live on his show, and I thought it was wild that he was on camera, that he showed his face, that he said his real name, and that he talked to him for at least 2 hours, right? I'm here to tell you, as a trial lawyer, that what Ronnie said is not uncommon. It's just not. It's just that we don't hear from jurors very often. We don't hear from jurors very often. The last juror I remember hearing from was juror number 1 in the Maya Kowalski trial. Jurors don't speak out that often. They don't give YouTubers interviews that often. And while it may be shocking and very disheartening for you to hear that, it is not uncommon. Most jurors do not understand what reasonable doubt means, and it needs to be hammered home. And I've been screaming that into a closet since this trial ended too. They just don't get it. Karen Read could be any one of us. You're absolutely 100% right. Tracy gifted another 5 members. Tracy, I can't even keep count so far, but thank you so very much for coming in here and gifting everyone with your presence and your presents. TS and CE. Thank you so much. Dobie Mama, thank you so much for tuning in from England. Excited for today's coverage. Thanking me for making this all understandable best show ever. Oh, thank you. Thank you guys for watching, because without you guys, I wouldn't have a show. Appreciate you. Kale has been here for 4 months. Love you with all of my heart. I love you with all of my heart, Kale. If I don't see you soon, I'm gonna die. Thank you. Thank you so much. Amy's Positive Pathways is here. The super chat was the Emmy for the Penny McGee and the jurors from the Karen Read 1.0 hanging out because 2 of them were together. Therefore, she had something to do with his death. Yeah, right. Different Emmy in the Penny McGee trial than in the Karen Read trial. Irene Scordi-Bello is the Emmy for the autopsy of John O'Keefe, and the ME for the Penny McGee case for her deceased ex-husband, Andrew Savitz, was Rebecca Diedrich. And that testimony is wild. If you haven't watched it, it's a short trial. I have a playlist on it. I think it's only 4 videos. Most of it didn't even have video. We had to just listen to the Zoom because Massachusetts didn't want you knowing about that persecution either. Bizarre. Thank you so much, Amy. And Trish is here. Bench trial is interesting. Bederow has said that's an option, but not with Bev. A while back on the Young Jerks, yes, he said that. He has said that with me as well. Thank you for all you do. Love you too. Love you right back, Trish. Love you more. Thanks for the 10. Sage says, I'm not a biomechanical engineer, but I did math. A car would need to be driving 2,000 miles an hour to project some 20 to 30 feet after striking an arm, 24 to 30 miles an hour if the torso was struck. I believe Trooper Paul got 24 miles an hour from that. No, I believe they got the 24 miles an hour from this alleged text stream data that they had. The problem with their text stream data is that there were no times and dates attached to it. And from what I've learned from Lexus and Toyota text stream data is that there absolutely should be a date and time associated with these events on the text stream data. So they did have some event with 24 miles an hour in reverse. It was just allocated to a key cycle number and not a time and date, which I am told is erroneous because it should have that data there. However, Trooper Paul either just deleted that column from his spreadsheet or wasn't provided with that information. Good morning, Judy. I did have somebody sent me something about this, and I was looking at the changes to Rule 14. And yes, thank you for that. There are new changes coming to Rule 14, and they're effective on March 1st. Rule 14 is the automatic disclosure rule in Massachusetts, and it governs what the Commonwealth must turn over to the defense and vice versa. Judge Cannoni was, to my understanding, one of the main proponents of this rule change, and she was, I think, maybe head of the committee. Don't exactly quote me on what her role was. However, somebody did send me a Reddit thread, and there is a potential change to Rule 14, or it's going to take effect on March 1st. And it looks like they will be allowed to talk about the federal investigation in court after March 1st. But I have not had a chance to do a deep dive into the rule. I have the text of the rule. Yes, you may be right. However, let's see, it's 14A1E. Not having had a chance to completely deep dive it yet, I don't want to give you my 100% opinion on that. But if we have a break, we can hopefully try and read it together. And it's long. It's very long. It's very complex. I didn't have the bandwidth to cram that in this morning and digest it enough. But it seems like, from a basic reading of the new Rule 14, they may be allowed to now reference the federal investigation, Judy. Thanks for the 10. We're going to have to take a look at that together. Kevin C. is thanking me for all I do. Thank you all for watching. Thank you all for watching. There's almost 8,000 of you here this morning. So thank you all so very much. Thank you, Kevin, for your super chat. This could be a long day. Could be a long day. But, could be a short day. You never know what's going to go on here. Could be like, yeah, we're going to table this for next time because you just got the opposition. And yeah, I'm going to take it under advisement. And yeah, you each have 2 minutes to speak. And John is here. John Concho is here. And he says, I'm shocked, Melanie, that you think Trooper Paul would know how to use a spreadsheet. Fans all the time. Smash the like button. Letteros by Bederow is here and says, when Karen Reed is acquitted, she would be the voice for the wrongly convicted. Just my opinion. I think you could be right. I don't know. She's wicked smart. Anybody who watched that Ted Daniels interview, his name is Ted Daniel, but anybody who watched Ted Daniels interview knows, or could see, I think, how wicked smart she is. It's the first time she really got a chance to speak to the public without being interrupted or sliced into, a bunch of different little tiny clippings, droppings, etc. So, thank you, Lisa. Thank you, Lisa, for screenshotting this for me. But let me see. Hold on a second. Is there a piece missing? All right. Thank you, Lisa. Thank you, Lisa, for shooting me the defendant's opposition to the Commonwealth's motion to exclude ARCA. Talk amongst yourselves for a second while I read this and digest while we wait for the court feed to start, and see if I can just give you a brief rundown of what they're claiming in their opposition. Defense is saying that the Commonwealth's motion to exclude these exculpatory expert witnesses, also known as the crash daddies, they didn't say that, I said that, Daniel Wolf and Andrew Rentschler, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The Commonwealth cites no legal authority whatsoever to support its extreme request to exclude these exculpatory witnesses. The Commonwealth falsely suggests that the defense has failed to comply with reciprocal discovery obligations under Rule 14, but its motion is improper, unsubstantiated, and contradictory to binding legal rules and precedent in Massachusetts, and if granted, would constitute an egregious violation of Ms. Reed's state and federal constitutional right to present a defense. The Commonwealth alleges the defense has failed or is unable to comply with reciprocal discovery obligations, and that it requested and has sought discovery from the defense and U.S. Attorney's Office pertaining to ARCA's witnesses for about 10 months. But as Rule 14 states, a defendant's reciprocal discovery obligation do not begin until after the Commonwealth's delivery of all discovery requests required pursuant to A1A or court order. Notably, the Commonwealth did not file its certificate of compliance until the last hearing on February 6th, and we know because we were there and we were watching. However, the certificate of compliance is meaningless because the Commonwealth has conceded that it still has additional mandatory discovery required under Rule 14 that it has not turned over to the defense. Here we go.
Ms. Reed.
Good morning, Mr. Alessi.
All right. Well, it looks like Law and Crime has the video up. Court TV doesn't. Let's just take it back a second so we can see everyone introduce themselves. The sound so far is not terribly great, but we're going to do the best that we can. I may have to lower my own volume. Here we go.
Jackson.
Good morning, Your Honor.
22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the
Good
Commonwealth.
morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
All right, they're having a sidebar. Let me see if I can find better volume. Otherwise, I'm going to have to turn myself down. And turn, so you can turn the court volume up. Tell me if this one's any better. It's really not. And in fact, they're behind. All right, what's going to happen is I'm going to turn my own volume down so that you can turn your volume up. Okay, we're going to test. Let's go back to when we hear the volume on this.
Unetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly,
That's
Judge.
court. That's me.
Mr. Unetti. Good morning, Ms. Reed.
Court.
All right, I was told counsel wanted to see me at sidebar.
That's me. NBC 10. All right, let's try that. Volume boosters don't seem to work on StreamYard. I've tried it before and I can't get it to work on StreamYard for some reason. That's better now? Okay, fine. All right, thank you.
Is start with, now I don't, what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at Mass Court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Paper
Good morning again,
479.
Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night,
Okay.
and on behalf of Fox or Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay.
That is
Alright,
for
I
the,
will. So March
that's for the Ted Daniel outtakes.
1st before they can get it here? Was that the
Yes, they
date you
They'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement, and the order is right here, Mr. Clerk.
There's one ruling from the bench today.
All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that,
thank you
right?
so
On the
much.
10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number?
Thank you. Just a second.
Okay.
Sometimes she does rule from the bench. I know it's shocking.
I'm sorry, the opposition. Too.
Defendant's motion to compel production of a forensically sound copy.
Because, yeah,
We'll get started in the argument and you can give me that.
evidence.
506.
Great, thank you.
That's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We're predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been
Since
one of the
day one.
centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR.
Mm-hmm.
Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there.
Right.
And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information. It's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video.
Right.
How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that, in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible.
Right, he did.
And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it.
Mm-hmm.
I'll submit.
It's very simple.
Mr. Brennan.
Mr. Brennan, what could you possibly say?
It seems like another effort to portray some type of injustice brought upon the defense, that half the facts are left out of the presentation.
Great.
So to talk about reality, the reality is that I invited them to come download the DVR, NVR.
Hold on a
when they
second.
full well knew that I had no idea if there was still.
My head's going to pop off. This is called cover your ass. He's going to cover his ducking ass right now, because he knows that he's going to be in deep water. And now he's like, it wasn't me. It's the Shaggy defense. It wasn't me. It wasn't me. It wasn't me. I told him it wasn't going to be there. And now he's going to accuse Alan Jackson of only telling half the truth. Okay, let's go. Start that again, because I can't even. Yeah, gaslighting, to say the least. Here you go. Yeah, courtesy, courtesy, courtesy. I'm the greatest. I've done everything. Bending over backwards. Not my fault. Wasn't me.
talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would there be 3 years later?
Why
And
would there
after
be?
they
I don't know.
filed a
Why would there
motion
be? Because
making
you're
rep-
supposed to put it on a legal hold, because that's your obligation as the prosecutor. As the prosecutor, you're prosecuting a woman for murder. It's your obligation to put that footage on a legal hold on the exact same system on which it was recorded. And it's possible to do that on the ExacuVision system because we know that. What a disingenuous.
representations that weren't accurate.
Why would it be?
I no longer have the confidence to have off-the-record agreements with the defense.
Oh, you no longer have the confidence to make off the record agreements with the defense? Oh, they're not trustworthy? Are you kidding me right now? My head's really going to pop off. Hold on, listen to that again.
Filed a motion making representations that weren't accurate. I no longer have the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th.
They weren't entitled to it.
And speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process.
Whose fault is that?
And I wanted to ask firsthand anybody that was there.
You had never been there? Whose fault is that? You have one job. One job. Your one job is the re-persecution of Karen Reed. You had to give up your defense practice to come in here for 75 grand at $250 an hour. And I'm sorry if you don't think that's enough now, but you have one ducking job, sir. I'd never been there before. What? This is unbelievable.
Russell, I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petra, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to.
Holy mother
When the
of
government would
ducking,
ask-
traveling Mary, there was never a motion. You as a prosecutor have an obligation to preserve any and all evidence, okay? There doesn't need to be a motion, my brother. There doesn't need to be a motion, but there was a motion to preserve all evidence from the day that Karen Reed was arraigned. That was retroactive to January 29th. We know all of that. We don't need to get into it. He is unbelievable right now. The fact that he can stand up in open court and say this. And by the way, what was that retired detective doing down there at the station when you went there? Who called him? Why was he there? He's retired. But you went there and there he was. And now he's explaining to you that, yeah, he has it, but nobody ever told him to preserve it. You've got to be kidding me. This is the alleged murder weapon, my friends. The alleged murder weapon that was in the possession of the Canton Police Department, Sallyport, who had been conflicted off of this case the same day that John O'Keefe's body was found. Okay. And now this officer of the court is getting up in front of a, this is so horrifically sanctionable. I can't even believe that he would get up and make this argument. I have to just rewind it a little bit because all of a sudden he's doing due diligence. He had never been there before. And now he goes there and the retired detective is there. Okay.
Who was there? DGM Petra officers. I wanted to do due diligence. And when I met with the chief and other officers, I was told by
Rafferty.
a retired sergeant who was there,
He was there.
DGM Petra, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. when the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. What he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before.
This is like
Wasn't a full accounting of all
this is like Harry Morrissey filing all of that ammunition evidence in the Alec Baldwin case under a different case number. This is what this is like. And why are they having this cover your ass meeting with Chief Rafferty, a bunch of other detectives, and this retired detective when he went down there? Does this sound to you like this was a complete, like, holy crap, what are we going to do? It's a cleanup meeting? Holy crap. Wow. Dismiss the case right now.
metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy.
We need the
After
logs.
you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it.
Baseless? Where's the metadata?
And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process. And that was
Due
metadata.
process. Did you hear the way he just poo-pooed due process as if due process is not a real thing? In the spirit of Brady violations and due process. Come on, we're Massachusetts. We don't believe in that kind of ducking stuff. Listen to that.
Request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process. And that was metadata. I don't even know if the detective file has metadata.
Well,
I
you
don't
need to.
actually know exactly what they're looking for. It is a simple
You don't know what they're
click
looking for?
and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we.
You mean because they're asking for the actual official footage with the actual official metadata to show that it's accurate and hasn't been tampered with? Yeah. All of these extra things they're asking for, they're the ones who want, the accurate stuff. We just want to give them what we want to give them, Judge. This is wild.
Want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process.
Oh, please,
so we'd
Alan.
like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
You should be horrified.
How quickly can you do that?
I imagine we could do it one day, but today it'll be done by the end of the week.
You want to make, I'll be heard briefly,
Yes,
very, very briefly.
take your time.
Take your time, please. I can't believe his head's not.
Brennan's confidence notwithstanding, I don't know what to say about that. Pretty immaterial what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, you know, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want the
October 24th, did that video come with the metadata?
No.
No, none of it has, Your Honor.
It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, and again, I'm no expert, my understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. There's metadata associated with all those things. It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate.
So you don't have the
They
metadata.
want to come, they're invited.
But in your opinion, the metadata is just an accommodation. Okay, got it.
Court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the video. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
Okay. Thank you very much.
Okay, what?
All right, Ms. Giannetti, the next one should be fairly quick and simple.
Okay, so what's the
motion for
resolution?
Prohack Vici. I asked you before when Mr. Alessi joined us, you have a rather vague,
Okay, here we go. Pro Hoc Vice of Mark Bederow. I guess metadata is not important, and turn it over if you don't have it. I guess there'll be another motion.
A good cause exists to grant this motion because Mr. Bederow, is that how you pronounce his name?
Yes.
Bederow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow
What?
the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare.
Oh, she
All right,
just wants
but I
more
need a
detail.
more detailed affidavit.
Your Honor, may I have just a moment with counsel?
This is a joke. This entire court is a kangaroo court. It's like a circus. Like worse than workers' comp court, which is a kangaroo court too.
Thank you, Your Honor.
Okay, the next one's paper.
May I be heard briefly?
Yes,
May I be heard briefly?
yes.
Oh, he's going to oppose Bederow. Oh, here we go. If you're ahead on another stream, please,
So
no
I did just
spoilers.
say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Bederow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Bederow is representing him for.
Yeah,
Now-
right. Because you're selectively prosecuting your witness intimidation statute. And yeah, those conflicts can be waived.
It's not great clarity, but it's been represented that there is a relationship between Mr. Bederow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Bederow, Mr. Bradel, have an understanding with the defense attorneys in this case.
Really?
That there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious
he
that
said
that
allegedly.
relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Bederow who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked. And
I'm sorry, are you in open court accusing Mark Bederow of an ethical violation? Because it kind of sounds like you are.
distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses and this information. If a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Bederow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Bederow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused.
The witnesses are being abused now? Abused. Because he's up there defending the McCabe's and the Alberts. That's what you heard, folks. That's exactly what you
I
just
have
heard.
to consider everything that was just said. But
That's exactly what you just heard. He's defending the McCabe's and the Alberts because they're being abused. And she's going to say, I need to consider everything he just said. Hold on.
Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Court. Relatively straightforward, but I'll hear you, Mr. Brennan.
Thank you, Melanie's
Your Honor,
interruption.
you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide defense copy if you want.
Yes. All right, so this is allowed.
Thank you, Lori Lake.
Right. So the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller.
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay.
All right. So they were actually, the O'Keefe family
All right,
agreed.
so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. And, I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But, we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
Let's wait. When I said both, I thought there were 2 points that you made up.
Understood.
All right, so
We haven't seen the motion for sanctions, but I'm going to assume it has something to do with this motion about impeachment evidence. And because David Dinetti said, I drafted this motion, I take full responsibility. I'm going to assume it has something to do with what was in that motion about either coaching the nephew to change his testimony or coaching Jennifer McCabe that she went to Lang's house.
Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense.
Congratulations.
Because it's my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, will be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Now he's so concerned about
I've been
fairness.
on the side where late discovery comes in a trial. And I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Comes Ms. Little, no relation.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with.
So you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or
Yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos, but that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is.
Yeah.
The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
Yeah, they're entitled to it.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Lank.
Yeah, tell 'em.
Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper, Garino. Lieutenant Brian Tully. Trooper, Kathleen Prince. And Norfolk County District Attorney, Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one.
Okay, if you haven't been listening, come back and start listening now because you may not know this about Garino, what he did in the Sandra Birchmore investigation, but she's going to tell us and the world. I'm going to take it back a smidge. Here you go. Listen up. Nicholas Garino on the hot seat.
The electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants affidavits are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They
She was
detail
15.
violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects.
Mm-hmm.
As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right.
Well done, Liza.
Mr.
Well
Brennan.
done.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked the chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request, I would look into any chain of custody information.
Wow. So he's pissed that they want something that doesn't exist, things that they are supposed to have, but they just don't exist. So he's angry that they're even asking for them because, you know, they just don't exist. Chain of custody logs, evidence logs, metadata. If they existed, I would give them to them. The righteous indignation and the audacity of this man are mind-blowing. Not just to me, maybe to you as well. Let me know what you think. Take it back a second. We're not just going
defense
to
has asked the chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a...
I mean, if we've already deleted them, they're gone. We can't provide you with things that we've deleted. Did they ever exist? Or we can't provide them with things that are already destroyed. It's wow, wow.
chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious.
What?
That these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out
The
terms and
defense
words.
would like to parasite onto the witnesses in the Sandra Birchmore case, who happen to be some of the same players that were involved in the investigation of a murdered Boston police officer, John O'Keefe, that is the subject of this murder trial. They're trying to parasite off of that. Has anyone's head popped off yet in the chat? Hold on, because I got to hear that again. Parasite is a verb now. Yeah, apparently. Chain of custody, never heard of her. Thanks, Rita.
Investigation.
It's
And
odd.
then list a number of witnesses for the Commonwealth, implying somehow something's nefarious. That these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety.
For the
There's
audience here on
nothing
our
that they
right,
have
that's where the media is sitting today. Usually they sit at this high top over here behind Mrs. O'Keefe, but today they're in the jury box. Did he call this also a conventional case? This is not a conventional case. This is one of the greatest cases of police corruption, cover up, and piss poor investigation that I've ever seen in decades as an attorney, as every other attorney who is willing to speak publicly about this case is also saying. There is nothing conventional about this case. And these people to your right and those same players are involved in this investigation. And if you can't see the connection there, sir, there's nothing I can do to teach that to you. Listen to that again.
And list a number of witnesses for the Commonwealth, implying somehow something's nefarious. That these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety.
An illusion.
There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists.
I'm sorry, you're going to have to scramble for that information? You're going to have to scramble to give them an unredacted police report on Birchmore? That's going to take scrambling from you? The only thing scrambling right now is your argument and what's inside your brain. That's pretty scrambled, but shouldn't be hard for you to get an unredacted copy of police reports that you're actually in possession of.
It's easy to throw out a name and attach it to the Birchmore case. Troopers, the DA, malign their name the way they know how to do.
The way
But
they
when
know
you're
how to
arguing
do.
discovery motion, there must be a factual basis for it. A factual basis, a good faith basis. We hear
Factual.
the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here.
Maybe you should
I
go look
don't know
for
what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience.
You're
And so
entertaining
the
us just
reality is
fine.
the Birchmore
Actually.
case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim.
She was a victim because originally they ruled it a suicide. But now she was a victim because the feds came in and had to charge Matthew Farwell with murder in a federal investigation. And your staties still have not charged Farwell with murder, by the way. But now, when it suits you, Ms. Birchmore is a victim of murder, not the suicide that all of your people that coincidentally were involved in the investigation of John O'Keefe ruled a suicide. Now she's a victim? Wow, Mizzy, your head must be popping off. I'm sorry, girl.
That case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case?
I'm sorry if you don't know why.
Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case?
Because they
Nothing.
ducked that one up too.
But invoking it is helpful for the defense. So they do.
She was
You should
murdered.
reject it outright, Your Honor.
She was murdered by the police. She was murdered by a Stoughton police officer. She was pregnant with his baby. He started raping her when she was 15. He took her virginity, and your cops covered it up. Your cops covered it up. And you have no idea what this has to do with this case? My pause game is on point today, and this guy is a disgrace. An absolute disgrace. He doesn't even know what the Sandra Birchmore case is about. Wow, just wow.
Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady versus Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth versus Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty.
You could hear a pin drop in that
Number
courtroom.
6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're over 500 at this point. So.
Yes.
We know.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion
So-called ARCA
to
motion.
exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan?
This is a motion to exclude the crash daddies, my friends, by the Commonwealth.
Sure.
Because they're really, really, really bad for the Commonwealth's case.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here.
Mhm.
The answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now having...
Well, it wasn't attached to your motion, sir. You expect the court to have a copy of the entire trial transcript of 10 weeks of testimony in front of her? Really? Mm-hmm.
Some familiarity with the federal government. It seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial.
Flavor.
So there is email correspondence between...
Let's take a poll. What flavor do you think he is, chat? Pick a flavor to name Hank Brennan.
the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd.
The Commonwealth should have an even playing field, and the defense should have the duck and metadata, dude. Liver, the liver flavor. You guys are good. Drywall, I think, is the winner so far. You guys are chatting so fast, I can't even highlight them.
Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attach my D&T.
Oh, he's reading an email from Dr. Wolf to Alan. Okay, hang on. This is what troubles him. This is what the biggest thing that troubles him about this trial is the email from Dr. Wolf to Alan Jackson. Here you go.
Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attach my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth.
Who's performing for the media now? Hank, who's performing for the media now? None of this was in your papers. None of this was in your papers, right?
Not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated.
It's not dated. There's no
The
metadata.
request
What?
is a recent February response, but they send random documents. There's no real accounting.
Really? Kind of like the lack of metadata on your video? Are you kidding me right now? You're outraged that there's no date on an email that was turned over to you? What? Wow. Funny how he can muster up all this audacity toward the other side when it suits him. But, you know, metadata is not important. We can't just invent things. We can't just invent logs and chain of custody and evidence logs and things that don't exist or that we already destroyed, Your Honor. But how dare they just turn us over a random email?
Now, I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses. but it certainly shows some bias. I've turned over a lot less in this case than this.
Oh, we know.
Another
Barely
comment.
anything.
Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So
Would it have?
special,
Because you know what? You can use that for cross-examination, sir. That would have been nice to have. You know what would have been nice to have? All the duck and video of the Sallyport that you turned over after the trial was over. That video that you turned over last week that's apparently exculpatory of Karen's Lexus backing into the Sallyport. That video that you turned over during trial that was inverted. That would have been nice to have too. But you know what? We don't have that luxury. You've got this in your hand. You can use it for impeachment purposes, obviously, instead of now raging fake audacity for the media. This is so beyond anything I've ever seen.
between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
Shh. Destroy all the video. Destroy all the metadata. Shh. Invert the video. Change the timestamp. Write down the wrong times on reports. Scrivener's error. We'll just say it's a scrivener's error later. Put all the wrong times on the search warrants. Shh. Look the other way. Pin it on the girl. She's a whack job C word. What do you mean you couldn't get the medical examiner to change her manner of death from undetermined to homicide? Rookie move. Rookie move. You should have had me that she go do it. Wow. Tell them the guy never went in the house. Don't tell them all the people that were in the house. Spell their names wrong on the police reports so that nobody can find them. Get rid of that library footage. Delete that Ring video from when Meadows of Karen coming home. Don't ask any of the neighbors for any Ring camera footage. Shh, we don't want that. This is rich. This is rich. Do you forget that Judge Canoni would not let Dr. Wolf testify about the cause of the injuries? Dr. Wolf or Enchler, I don't remember which one, because he was not a medical doctor. And he was going to opine that the injuries sustained by John O'Keefe did not match up to a pedestrian versus motor vehicle accident. He was not allowed to testify to that because he was not a medical doctor.
If you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's
Wait, when did they pay them?
So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works.
Shh. How's long to die in cold?
Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and
Ghosts?
say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions.
You don't care?
But I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
Oh, she's taking a recess because he thinks that he just had some kind of mic drop moment right there. Did you see how theatrical that was? he thought he had some kind of mic drop moment because there was a bill to the defense for $23,925. But when was that bill? Was it before they testified, or was it because they hired them after the trial was over? I want to know. Does anybody know? Did anybody catch that? Wow. Cue dramatic tapping. Oh, this will give us a chance to catch up to real time because she's not happy. Let's see. OnlyFans all the time. Look at us. We're going to catch up to real time. Why do you think she's taking a break? Does she have to go powder her nose? What do you think? Well, that's okay because we have a lot of questions in the super chat, Shalom. Oh my. Oh my. He really thought that was his moment, you guys. He really thought that. I've been putting super chats up as we go. So a lot of them were just comments. So hopefully you were able to see them. Whatever, Clever, can you explain what the jury can find on count 2? I cannot until I have like an entire show to describe that. I appreciate the question. Somebody asked me that yesterday, but that would take way too long to do when we're doing a live hearing, but I will star that one for later. And I have to pull up. I don't even know if I have the final amended jury verdict slip on that one. So if anybody has count 2 amended verdict slip, please email to me. I would love it. My email is always in the show notes in case you're looking for it. Sage, thanks for the 10. I know there's supposed to be time, but key cycle 62 wasn't when Karen Reed had her vehicle. So is it possible Trooper Paul did the math, then used her car to reach 24 miles an hour and then said this is the key cycle? Anything is possible, Sage, in this trial. Anything is possible. It could have been when they were backing up out of the driveway to get it onto the tow truck because we saw those wheels spinning. And thank you for your super chat. I bid him, I bid him. Thanks for tuning in from Canada. Karen's Life 360, wouldn't it be the same as John's? I don't know that they had Life 360 on both of their phones. I'm not aware of that. I don't know if you're talking about Apple Health data, but a lot of people have suggested such a thing with regard to the stairs. If you didn't go in the house, do you think they will call Michelle Littlefield for the defense? I don't know. I don't know what she would add to the defense. Michelle Littlefield is the town employee that was fired for running a plate for Aiden Carney. So I'm not sure how that helps Karen's case. Oh, to say that Jen McCabe went to Lank's house or to Proctor's house? I don't know. I don't know. Maybe. GB, new YSL judge ordered the whole prosecution team, including the DA, to Brady training, and that was glorious. We want that. Well done. Well done. Thanks, GB. Irish Wolfhound Mama, thank you so very much for your super chat. Kyle has put in a whole bunch of super chats here, and they were mostly comments, so I kept putting them up. So hopefully you had a chance to see all of his enlightening comments. Thank you, Kyle. Says, I pulled stuff and archived it many times. I had standing orders to preserve anything from weird incidents. Proved up a lot of them too. I'm guessing you're either law enforcement or tech. Thank you so very much for chiming in so often with your great comments. And more of a Lessie, thank you. Says it's hard to stay classy. T-Mac, thanks for the 10. Apple TV has a show called Presumed Innocent. I watched it. I thought it was great. Jake Gyllenhaal. And I think the opening scene is what the defense needs to adopt regarding reasonable doubt. Well done. Kirsten imagined a chipmunk named Brady full-throated. Very funny. Thank you, Kirsten, for tuning in from Canada. Orwellian Unperson, thank you for the 10, says, confidence? He has some nerve to talk about trust and confidence. My head is about to explode. What the hell has Bev not exploded on these guys? I've seen judges lose their duck for less. Thank you. Dennis the Menace says, fact, jellyfish do not have a brain. Brennan is a jellyfish. Thank you, Dennis. Thank you, Dream, Karen Reed's Revenge, for the $100 super chat. You're so generous. How long is Judge Cannoni going to allow this crap? This is disgusting. Why am I in tears at this keyboard, heartbroken for Karen Reed and this band of thugs trying to further destroy her life? I am horrified. F off, Brendan. Thank you. Thank you so much for your very generous super chat and for venting your feelings. We're here for you. We feel you. We see you. We are in agreement with you. Cherie, thank you for gifting 5 memberships. You're so sweet. Suze, hashtag Hank wants metadata for Karen's phone and records and refuses to provide what Karen's legally entitled to. Yep. Thanks for your super chat. Piney Woods, thanks for the 10. My lawyer's heart and mind is with you, sister. I'm floored with Brennan's arguments. I may have to leave the stream for a bit. The court should dismiss. If you need a break, take a break. This can be very overwhelming and stressful. And I don't know. We're in the Twilight Zone. We're in the Matrix. We're in the Upside Down. We're in Narnia. If you have a better word for it, please feel free to chime in the chat, because those are the words I've come up with. It is the Upside Down that is Norfolk County, Massachusetts. And we're here. We're still here. Edward has also put in a whole bunch of super chats, and some of them have been comments. I've just put them on the screen. He says, this is why I can't be a lawyer. I would be foaming at the mouth, angry at Brennan right now. But Jackson is very restrained. I agree. They're showing a lot of restraint. I'm so glad I'm not in the courtroom right now and I'm here with you so I can yell into the camera and the mic, because if I was in the courtroom, I wouldn't be able to hide my emotions either. So yeah, it's hard. Thank you, Edward Kirkpatrick, for all of your super chats today. 20th Century Fox. How has Hank effectively defended anyone without knowing of the existence of metadata? Yeah. And it's Carney. It is Carney. Random Thoughts. Thank you so much for the 50. So generous. And there isn't a problem, curiosity, between a retired cop having active evidence in a murder trial. Oh my gosh, who is the gaslighter here? A circle of defense lawyers protecting someone's rights, or the Commonwealth using word salad that has rotted. Well done. We have an emoji for that. We have so many emojis for this trial for members. We've got that word salad emoji. We've got Twilight Zone. We've got what if any. We've got the puffy jacket, the solo cup. So many members. Feel free to use your chats. I mean, your emojis at your leisure, because so many of them are appropriate here. Just Joey, whose phone is being tapped to know how many calls Turtle Boy has had with Karen Reed's attorneys. They got Aiden Carney's phone records. The prosecution did in the prosecution of Aiden Carney. In that case, they have his phone records, and that's how they know. Thank you, Joey, for your 5. Spoonful of Snark. It's curious, like almost like all the defense lawyers are colluding to expose the disgusting Commonwealth, right? That's what I can't believe, that argument on Bederow to keep him out. There's a conflict. It's a waivable conflict, in my opinion. It's a waivable conflict. If Karen Reed and Aiden Carney both sign waivers, and I'm sure that before accepting this assignment, Mark Bederow has consulted with an ethical attorney, because there are attorneys who specialize in ethics. That's crazy. Poison Ivy, thank you so much for your 5. Brennan needs to carry body chalk around. He's a victim wherever defense asks for evidence. And at the same time, he appears to believe he's a saint. Oh, well done, Poison Ivy. Well done. Thanks for your 5. Alicia, thanks for the 5. Shame on Brennan. This is gross. Kelly Jane says, if Hank's voice didn't make me want to rip my hair out, this BS he's spouting certainly does. Good job. He isn't Pinocchio. As Bev would have lost an eye. Well done, Kelly Jane. Well done. You guys are the funniest chat on the internet, and you know it. You know you are. And here's Edward Kirkpatrick again. I'm tired, stupid spirit of cooperation from the Commonwealth side. I picked up my clothes after I took them off and threw them on the ground. Praise me. Melissa, thanks for the 5. Can't Brennan be held accountable for withholding evidence? Yes, it's called a Brady violation. It's a problem. And it doesn't matter that he wasn't the attorney the first time around. Everything's imputed to him. So there's that. And who is above Bev to stop the circus? The DA could dismiss the charges. The feds could indict somebody else for this crime, but they won't do anything until I think this persecution is over. And also their investigation is still ongoing. So praise be. Nina, do you think there's a conflict with Mark representing Karen and Turtle Boy, or is it a nothing burger? Yeah, as I said, I think it's a waivable conflict. I think that their interests are aligned, so I don't see them having opposing interests. And again, that would be something to discuss with an ethics attorney and both clients, and have them waive it. And I'm quite sure they probably dotted all the I's and crossed on all the T's on that one. But Brennan has something for the media. It's a soundbite for the media. Greg, my guess is the sanction is most likely about the content of the child's testimony. That may be true, because I think that the kids' testimonies were under a protective order. I know that we weren't allowed to see it on TV, but I'm not quite sure because I don't have a copy of that yet. Karen says Bederow is at his office doing the motion to dismiss. Thank you, Karen. All right, here they come. Except their sound is not up yet. Thank you, Kyle, for another super chat. Maybe you guys want to put your sound on?
Of that information, grave Commonwealth. All right. So the Commonwealth just provided the court with information that causes me grave concern.
Grave concern?
The implications of that information may have profound effects on this defense and defense counsel.
What?
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
What?
So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
What? What? They've just been provided with information that causes her grave concern. She's suspending this?
Where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute.
Oh, we find out.
The
Hold on.
chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Hold on, we're going to have to regroup and rewind and the defense.
The discovery that was
Thank you.
provided by the defendant reference card.
Oh, great, thank you. We can do the afternoon of the 25th if the morning doesn't work.
25th is next Tuesday.
The problem I have, Your Honor, is I've got a hearing on the 24th.
You can take a red on Mr. Jackson.
So you can be on Zoom for this if you want, Mr. Jackson.
I mean, she's mad at the defense.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
You could take a red eye, Mr. Jackson.
May I have just a moment?
She got information from the Commonwealth that has so enraged her that she is shaking. She took a break, and now she's saying they have to come back a week from today. She's suspending everything from today. She is so outraged, and I think she's angry with the defense. I don't know what it is that the Commonwealth turned over, that Hank misstated the facts and said that the feds gave them those emails when the defense gave them those emails, and it had to do with the federal contract ending. And then I've been screaming all along, that's great, because now the defense can hire them. And now he showed up with a bill, but he didn't say what the bill was dated,
Your Honor, we'll
23,000.
accommodate the 25th, one way or the other.
All right. So we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
Okay, they've just suspended this hearing till the 25th at 11 a.m. So I think it's because they said no one paid them, and now the defense has shown they did pay them. But when did they pay them? This is a distractor. She is so angry. Did you see how much she was shaking? Yeah, we're going to rewind it. We're going to rewind it. So just hang on. But Brennan did walk it back. And she said that holy drama is right. Well, hold on, because we're not done here. We're going back. I want to see what happened right before she said she took that break and she went back there. I don't know if she took a phone call. I don't know what happened or what had happened, but she said that they gave her something. The Commonwealth gave her something that enraged her.
Consistent, the best I can.
And these emails don't have dates on them. So we're going to take it back to where he starts pulling out these emails, Brennan, and talking about it.
What we see back in March 22nd, 2024, provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, two requests.
Okay, so I'm going to just speed him up a little bit because he's a slow talker. So let's try and get the gist of this. Hang on. This was produced by the feds.
Necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, two requests, and insistent, the best I can, to get as much information as I can. We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally.
Okay, so I think what he's saying is, here's what I think. I think that he's saying that the defense said they did not prep the ARCA witnesses, that they were not allowed to speak to the ARCA witnesses before the trial, that they said that in open court, because remember, he pulled out that transcript and he started reading that transcript. And now he's pulling out emails between the defense and the ARCA witnesses that he says were provided to him by the feds, and that they were outlining questions they were going to ask them at trial. So he's saying that they lied about it, but hang on.
Independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury. It doesn't matter in this case.
The date of that?
It's not dated. It's not dated.
It's not dated, so it could be after. It could be after the trial. They could be talking to them in preparation for the next trial. So I don't know.
The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this.
Right. They could have, I don't know, voir dire? I don't know. Hold on.
Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault.
He said in my testimony. So it's as if he's already testified either at the trial or at voir dire how many times he's been qualified. It could have been after the voir dire, before their testimony, or it could have been after the trial in preparation for the next trial. We don't know because he said he got this recently from the feds as in response to a TUI request from the feds. But why would the feds have emails between ARCA witnesses and the defense? I don't think that they would. So whatever it is that the judge is outraged about, maybe like after trial, it's unclear. Let's keep listening and see if we can do a little more armchair detective work.
11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925.
What's the date on the bill?
That's not Trimble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases.
You didn't know any of this until when? They're not done turning over their discovery yet. So they may have yet to turn this over. So hang on. Right. And it wasn't from the feds. It was from Alan. So what is she, right, of all the things to be upset about, this is what she's upset about? Hold on. Keep going.
I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. Create
Ghosts.
illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I welcome ARCA.
I'm going to take a recess.
All right, please.
Okay. And then she takes a recess, and let's see how long this recess was. Let me just. But he did say he got him from the feds, right? Pursuant to a TUI. All right. So this is the 39. She took a recess for like maybe half an hour. And then she comes back, and this is what she says.
All right. So the Commonwealth just provided the court with information that causes me grave concern.
Okay. Whatever the Commonwealth gave her causes her great concern. I'm going to put her back on normal speed. I should slow it down and listen to her in slow motion.
The implications of that information may have profound effects on this defense and defense counsel.
Wow. Meaning she's either good. She could could she revoke their pro hoc vice status? Is that what she's threatening to do? And yet all these Brady violations don't shock her. Somebody said she had to call Marcy for next steps. Okay, listen, hold on. It could have grave implications for the defense and defense counsel. Hold on. Here again, she's breathless.
The court with information that causes.
Hold on.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today.
But she doesn't say what it
at
is.
11 o'clock in the morning. You can tell me now if that is impossible for you.
All right. But then he corrects himself and he says,
and where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense.
Yeah,
February
it's the
13th,
defense who provided
2025,
them
they
with
sent
those
us the
emails.
Emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
Okay.
It would have to be at 9 o'clock in the morning.
Here's the chronology. First of all, he misstated the facts in his original argument there because he said that the feds gave him these emails when it turns out that it was actually the defense who gave him these emails, and everything was after the first trial. So December 4th, there was a two-way request. January 6th, they filed their motion. The 30th, the U.S. attorney responded. February 6th, they were sent an email by the feds that they were done with ARCA and that their contract was over. And so then on February 11th, he said they made a motion to exclude. And then there was emails provided by the defense on the 13th. That's all after the trial. What about the payment? It's undated. So now she's forcing everyone to come back in a week. And I mean, she sounds like she's threatening them. It's of grave concern to her. Such grave concern, like she wants everybody to come back and have the whole week off to think about it and come back to be prepared. Let's go to the chat for a minute. Thank you. Did I bite him? Yeah, I bit him for your 20. Says Liza is the silent assassin lover. We're women warriors. Thank you so much. We're going to, we may have a special guest coming in here to yell with us in about a second. So hang on, like and share, everyone. I'm doing the Lord's work, says D1111. Piney Woods. Does the judge not have a bench book for this case? She really doesn't prepare much. They're supposed to have like a little bench book up there, a little rule book. Edward says there's no witness. Did the video magically appear? Motion to exclude all the video then. Thank you, Romy. Thank you, Cambat. We need a Who's Afraid of Little Old Me shirt for Bederow, says Romy. Sweet Caroline says, please reassure me that's enough for the feds to storm Canton PD. Well, I don't know. Sounds like the judge wants to revoke some pro hoc status. I don't know. We'll see. The federal investigation is ongoing, and there's nothing wrong with the defense hiring the ARCA experts, by the way, after the trial. So these emails aren't even dated. They're not even dated. So he couldn't even say if this was during the first trial. Chloe Albert's revenge, thanks for the 10. Commonwealth doesn't want them seeking things that don't exist. How would they know that when they're staging a second trial for a crime that doesn't exist? Excuse me, we thought existence was optional. Of all the things to outrage her, that's what outrages her? Thank you, Ellen Victoria. Thank you, Misha. Thank you, Greg. Thank you, Greg. Thank you. Thank you. We have a special guest here. who's outraged just as much as we are, everyone. Please welcome Ali Mata from Defense Diaries. She's texting me like, girl, let me on. I gotta.
I know, like right out of bed. This is how irritated I am that I don't even mind going on looking like
You look
this.
gorgeous. You look gorgeous as always.
So, uh, I mean, she was visibly shaken. And I'll tell you, at first I was pissed because I'm like, I don't get it. She can get visibly shaken. She can find something immediately wrong, offensive, warranting her comments right from the bench.
Wow. Because we've
But
never seen that before.
No. And I think there's been plenty of times that there was like, even if you're her, an inkling of something that should have made you say, wait a minute, Commonwealth, what the hell are you doing? And I'm going to try, because I know your rules about language. I'm going to try ducking if I.
It's all right. I think we're past that at this point, or my head's going to pop off.
So it seems like she can't remove which one's local?
David Yannetti.
David Yannetti very easily because he's local counsel. That is going to take a lot. With Alan, he's pro hoc vici, and she may just very well revoke his status. And
hang on 1 second. I just want, you know what? I want to modulate my volume and your volumes because I had my volume down. I'm gonna just so everyone can turn their own volume up now because we are done with the court feed, which had crappy volume. So everyone just modulate so that we will be regular volume now. Take it away, Ali.
So I've had this happen to me in a high profile case. So this is shocking. And maybe, but your friend attorney Bederow will have to be the only lawyer moving forward.
But he's New York.
No, I know, I'm being facetious.
That's what I mean. Like they won't even, like, if they're gonna, she certainly wouldn't let him in, and she'll have to. I mean, but here's the thing: like the sequence of event. What is it that freaked her out?
That's what I was going to ask you, and I went back and listened. So, did they ever say they never paid them any money?
I don't think so. Not maybe during the first trial, but see, all of this stuff happened. This all surfaced in December. He said he sent a TUI request in December of 2024. That's after the first trial was over.
So I'm wondering if what freaked her out the most, and Bob and I were just kind of chatting about this, is that he presented them as completely independent. Now, here to me, and Bob and I were talking about this as well. They did an independent evaluation. They were not hired by either side. They did a completely independent examination of the evidence, evaluation, and came to an independent conclusion in this. But yes, then based on that independent conclusion, they became a defense witness. So, I don't understand why it would be a very big deal if what her issue is that they presented them as a defense witness and then didn't share the direct examination questions, because I get questions from my experts all the time. I don't give them to the other side. So I don't know if she felt that those questions should have been discoverable, and if she felt that the answer that pedestrian accidents happen more at night that was not disclosed to the other side, which maybe technically should have been disclosed to the other side. If that's what's got her outraged, but she's not breathing. Like she is
The inverted video is okay. Like this is like, of all the things for her to get upset about,
that's,
he read a transcript of something that allegedly happened in open court from the first trial, where I guess it was Alan Jackson said, we weren't able to speak to them before the trial because the feds said that we couldn't, or something like that. And so he sort of made it seem like we didn't get a chance to prep them. We had no conversations with them before their testimony. And then depending on when these emails are dated, that would contradict that they did have conversations via email about what their testimony would be. But as you know, from hiring experts all the time, it's very common to speak to your experts before trial.
Right.
Is it his misrepresentation, his potential misrepresentation to her that he didn't speak to them? But we don't know when these emails were dated. We don't know if they were after the trial, if they were just from recently. Once the feds said they're not under contract with ARCA anymore, the defense is free to go and hire them, right?
Yeah. And it could have been after, because remember, all those things you just discussed were statements that they made before the voir dire. So maybe after the voir dire, whichever way, then they opened up the lines of communication, because that email was, your questions were, perfect for the voir dire. Or did it seem like he made those for direct examination during the voir dire? Do you remember which it was?
It was after the voir dire, because he said, do you want me to correct it? Because I have testified as an expert only 11 times, not 20. It was like 11 times and then 8 times in depositions or something like that. Do you want me to correct it? So it may have been that after the voir dire, they were in contact.
Right.
But
And that could
there's
be
no
another
date on
one of
that
her
bill.
one of her issues, that they should have produced something in writing to the judge saying after the voir dire, he clarified that this was his level of experience, or whatever the
Right.
case may be. And I don't know, do you know whether they ever relied on that higher number? Like, for example, in their response to the motion to any motions or at trial, do you know
Does
if they
Bob want to come on? Where's Bob? Is he in the other room?
he's upstairs?
He's like, this may be a huge deal. If he wants to come on, we'll send him the invite. It may be a huge deal, but it may be nothing, because these are undated. Could it be after? I mean, this $29,000, it could be prepayment for travel and expenses that they're going to incur. It could
I
be
don't see
for
why
an
that's an
updated
issue.
report.
Can you see why what they paid them is an issue? Unless they lied during their cross-examination at trial and said they were not paid. I don't
Right.
understand how payment is an issue.
Unless they really did pay them. But if they did pay them, why wouldn't they just disclose it? Why hide it?
Did they say, but you don't recall, as you sit here, them ever saying they never paid them?
I don't recall that. I don't recall this was so long. God, it was like almost a year ago. Whether they were asked
Right.
if they were paid by the defense.
Right. So, and I think Bob is saying this is a huge deal, because whatever she does is going to, if she attempts to remove any one of the lawyers, that is going to result in a delay in appeals to the Supreme Court, to as far as they can go interlocutorily, because that's obviously the hugest issue. We saw it in Richard Allen. For anybody who follows that, you cannot just remove someone's chosen lawyer. So, but again, it will be easier with Alan Jackson, but I can't imagine that they're not going to want to put up a fight. So I think when Bob's saying this is a huge deal, it's clear that Bev, at least at the present moment, Judge Cannoni, is seeming that she wants to take some sort of action against the lawyers. And if she does something to interfere with their ability to represent their client, removes one of them, that's going to delay, that's going to cause, a lot of issues, even if it's just Alan Jackson.
Yeah. Ted says Alan Jackson was directly asked outside court minutes ago if they paid the ARCA experts during the trial, and he said absolutely not.
Well, then there you go.
What kind of emails don't have dates? Like, why was she so visibly shaken? Like she was gonna lose her shit. But it was like almost like, okay, the inverted video comes in during trial, and it's like no big whoop. Brady violations everywhere. It's like the Brady Bunch. There's so many Brady violations. But now Hank Brennan comes in waving around an undated email. And first he lies and says he got it from the feds. And then he corrects that at the end and says, oh, no, by the way, the defense provided us with this. It wasn't the feds.
Right. That's a huge difference. That's a huge difference, that the defense turned it over versus they refused to turn it over. We had to get it from the feds.
And they're not even done exchanging discovery yet. So I'm confused.
So the defense actually are the ones who turned over the questions?
Turned over the emails that he was referencing, that he was waving around.
So
that was
she's
my
all
understanding
got
of
her
it, right, you
panties
guys?
in a bunch over nothing, it sounds like.
I mean, it sounded to me like it was such a horrifying ethical violation that she could not even digest it. Like she was so blown away that this may have grave implications for the defense and the defense attorneys, that you all need to be here a week from now.
I think she's been waiting for something to come, that she
For a
could try to
reason.
remove these lawyers, because that obviously that changes the entire landscape of everything if her lawyers are removed. It seems like she has been waiting for something to pop, and maybe that breathing that we heard wasn't really outrage as much as it was excitement, anticipation. I mean, it's just to your point. How do you not get outraged when in your court of law, in your courtroom, the Commonwealth puts on an inverted video and has a witness testify that it accurately depicts the situation in front of them?
Right. It's
How
a
do
fair
you-
and accurate representation. And then after a weekend, he comes back and is like, oh, yeah, except for, it's mirrored. So, like in a mirror, like you see things backwards, like that's what that is. And then all of a sudden he couldn't remember that it was really him over there and really Proctor over there. And he's like,
And
wow.
just you've got officer witnesses, deleting things. It's like none of that prompted her to ever say anything from the bench that like fall in line, clean up your like clean shit up. This is take this stuff more seriously. Not any sort of reprimand from the bench. And now she's visibly shaken.
And I didn't even like see him handing her anything. She said the Commonwealth just turned over some things to me that are deeply disturbing. And it's just beyond. I want to see. I think I have a clip of Alan talking to somebody. Hang on a second here. Let me just see if I can. Hello. Maybe not. I mean, it's
I don't think he gave her anything. I think she went based directly on what he said right there.
yeah. I thought she said that he gave her something. Like the
think she
Commonwealth
just
has just given me something.
provided me with information, and I think it's just what he said, and she took that to mean.
Yeah.
I think she took it to mean these were things that they had from trial. Do we know if that's what he was saying or not? Was he saying it was because he said these things would have been good to have, as though they existed before trial and were never turned over until this second phase of, this second trial.
Except that he couldn't put a date on the email. And we can go back and listen to it again. Let's go back and listen to it again.
People in your chat are saying that he did ask if he could approach the bench and provide the
Oh,
court
he
with
did? All
something
right, let's
at
listen
some
to it
point.
again.
Our involvement will move forward. Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning,
Okay, so that was June 22nd. And I think that was before they testified. If anybody in the chat can notice, can look up when Daniel Wolf testified, that'd be great.
putting together a brief outline of my qualifications, also attach my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel.
So it was after the voir dire, but prior to his testimony, is what I'm gathering.
Yes.
Feel necessary.
They testified on the 24th. Okay,
Now, this isn't
thanks.
information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can.
But I think he misspoke there because then he corrected himself to say that that was really provided by the defense.
Okay, because that is, again, a huge difference.
Right.
We then are provided an outline. An outline.
I want to go back. I want to go back and hear him read to her what was said in open court because he reads it from the trial transcript. Hold on.
The answer.
Here it is.
Sure.
All right, we're going to start from the beginning of that motion.
All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan?
Okay, there's a replay for those of you who are joining now. We're trying to figure out what what Canoni is so upset about. Oh, it was Christina Rex that asked him that? Okay, look, I'll look for that.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
So, I mean, their background and their experience, that goes to how many times they've been qualified as experts, right?
Right. So that very well could have been, we don't know if the questioning, the outline of questioning dealt only with that. It may have. However, we are going to hear him get at least into one question about the pedestrian, but.
Right. Okay. Moving on.
Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses.
Okay, so this is March 22nd of 2024, before the first trial.
Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required.
So they paid him a retainer in March of 2024 before the first
Commonwealth,
trial,
as I
and they said
understand
that
it.
they didn't?
Do we know they said that they didn't? Is that what, did I mute myself? No. Is that what
Yeah.
he just said?
I mean, I think that they said in open court, we didn't have a chance to prep them. We didn't have a chance to hire them.
And someone in your chat said that Alan Jackson just said again they absolutely did not pay them.
Well, I mean, an engagement letter would say that they're hiring them,
Yeah.
right? And maybe they could, yeah, maybe it could be for scheduling travel and stuff. That's true. Travel, hotel, lodging. Alan said
Right.
he didn't pay him outside court. Okay. This could be nothing, but it could be something.
Could be
Let's keep
something.
listening.
And I'm watching, I keep zooming in on the defense
The-
panel for their
Yeah, me too.
responses. See some drinking water, a couple little coughs, but so far they're not giving away anything.
They did testify in open court that they didn't pay for the report. Okay, hang on. Let's hold on.
I will get that countersigned and returned to you
He wouldn't
forthwith.
lie about that.
Daniel Wolf.
Okay.
Is
hang
that
on.
there are conversations we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required.
Retainer,
Commonwealth, as I
along with your retainer as required.
It could be a travel
It was not
retainer.
Could be.
aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward.
Okay.
Okay, so they paused it.
Right. They're like, we're
because
not
The feds said to, because maybe they were still under contract with the
right.
feds, right?
So that sort of undoes everything that just happened.
Right.
It's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
D&T, like a deposition and testimony list, right?
I think so, yeah.
So all the cases he's ever
All the cases.
given depositions in, all the cases he's ever testified in, and they're entitled to that. The other side is always entitled to that, right?
Yes.
For experts, okay.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth.
When they did their
What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting.
But then he corrected himself and said he got it from the defense. So I'm confused about whether he got this from the feds or from the defense.
There must be some of both. There must
Maybe.
be.
So he's saying we need to convince them that having all that other data or inspecting the vehicles doesn't matter. I guess that's
Right,
was the
which
sum and
is-
substance of that conversation.
Right, which I don't think that is something that would be discoverable or is important. That's not really anything about his opinion, his findings. That's just him saying this is something we can explain to the jury is normal, and it's not.
Mhm. Right. All right. Let's keep going.
Now, I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this.
No metadata.
Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine.
Could that be bad? That could be bad.
Don't tell them.
But isn't it also obvious that a lot of pedestrian accidents happen at night? I mean, I don't know. You think that's improper?
I would agree
I'm
that
gonna
it
pull up this
is
testimony if I can find it.
That it does kind of go without saying that the worse the lighting conditions, the more inclined there is to be a pedestrian accident. But I do think that is something that they should have disclosed. But I say that, but now, and I'm only going off of Indiana law because this issue came up in Richard Allen's case, and I asked the lawyers, well, isn't this a Brady violation? Why didn't they tell you this information? And they said that in Indiana, because they do depositions in criminal cases, which they don't in Illinois and they do in Massachusetts, that what has to get turned over by an expert is not as in depth. And I have heard the defense here in this case recite the rule, and it does not seem like it's as extensive as it is here. So, why didn't they depose? Well, they couldn't depose them. So
Yeah, they don't do that.
if it's not part of their, if my expert tells me something that is damaging but not specific to their opinion is like how this accident happened. The fact that he also happens to know that more pedestrian accidents happen at night is not directly related to his testing and opinion in this case. So I don't think it's as troubling as it would be if he had said something like, well, but when we did the testing, we didn't consider X, Y, and Z, and that might have had a role in it. You know what I mean? Like, this is very peripheral to anything. It's just sort of general information that general knowledge an expert has that I don't think was relevant to their opinion of the evidence, to their actual testing here. So for that reasons, I don't think it's as big of a deal as she's making it, but is it something? It could be, especially if it came up at all about pedestrian accidents, times that they occur, when they occur. If his testimony touched on that at all, then, they definitely should have had to turn it over. So, I guess we'll see when the defense responds to this.
Pinky, I see. Hold on, Pinky, I see this, but are you talking about the law and crime feed? Because that's the feed I have pulled up. So is that the law and crime feed that you're talking about, or is that the court TV feed? I need a little more information on which feed that is, because I have it pulled up. So just hang on for 1 second. Just sorry, Allie, to interrupt you, but Ashley said that Nick Rocco said that this is just, they've been looking for a reason to kick Allen off the case, and this is what they are going to hear. They're going to try and kick Allen off the case. They're going to try and take Allen off the team now. That's what this BS was all about, says Ashley.
Right. And that's what Bob, as soon as she said the words, we were like, oh, they're pulling his pro hoc vici status, period. Like, and that's why I am saying, like, to me, I question what she was so shaky. Was it excitement or was it outrage? Because how to not get outraged over any of the things that the Commonwealth has done.
I know.
And maybe it's more like, oh my God, I might be able to get rid of Alan Jackson for this. This might be something.
Right. I don't like these. She never liked the LA swagger lawyer anyway, to begin with. Hang on a second, because I have a tweet here from Christina Rex. So let's just take a minute and take a look at this for 1 second before we go back to that, which says, she says, I asked Alan Jackson outside of court if he paid ARCA to testify at trial number 1. No, of course not, he said. In court, prosecutor Hank Brennan read documents, including an alleged bill from ARCA to the defense for $23,925. That's getting duped, he told the judge. So that is, apparently she spoke to him outside of court.
Listen, I don't see why in a million years, I mean, just looking at this objectively, why the defense would actually lie about it. It's almost the extreme. It is the extreme unusual case where A, you're not allowed to talk to your experts, but B, you're not allowed to pay them. Nobody comes to testify for free. They did not pay them to do the investigation. They did not pay them to do their testing. But nobody would ever assume that they were coming up and testifying for free. You still have to pay their travel time, their court time, their expenses. Like that's not a freebie. So I don't know why he would say, I asked him outside of courts if he paid them to testify at trial. No, of course not. There's something that we don't know here. Like that 23,000 is, like you said, either afterwards or whatever the case may be, but there'd be no incentive to lie. It's not like that's going to make a difference with the jury, with the judge, with anybody, because it's normal to pay experts. And the fact of the matter is, no matter how you slice it, no matter if they paid them $1 million to come and testify, they formed their opinion independent of either party in this case. It's an independent examination.
Right. And not only that, but the Commonwealth had the same opportunity to contact them and speak to them because they were an independent expert hired by the feds. So the Commonwealth could have reached out to them. They could have spoken to them. They could have hired them. And really, if it was about getting to the truth here, instead of just getting a conviction, they would have. They would have called them to testify because they would want to get to the truth too. Right.
Yeah, I was saying to Bob when because he was watching your live when I woke up, I was like, all that talk of this guy when he started, that he's going to look at it with fresh eyes and he's going to, really scrutinize the evidence. And I don't see any of that. He just keeps saying over and over how fair he is, all the things he's doing, going out of his way, this, that, and the other. But he's not actually scrutinized the evidence. That is crystal clear.
Yeah.
He didn't bring fresh eyes to determine if the charges are warranted and if the evidence really exists.
Yeah. He didn't. So it could be nothing, but let's listen to a little bit more, and then let's look. I'm going to go back to Dr. Wolf's testimony in a second.
Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times. When you asked how many I've been qualified, I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925.
Okay, but there's no
That's
fee
not
on it.
trial. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced.
He cares because it hurts his case.
Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the recess.
I mean, she's visibly shaken, and then she comes back.
Right. He hasn't given her anything as of yet.
Right.
Unless,
so let's see if he does.
Right.
Hold on. I mean, she walks off. It doesn't look like he handed her anything.
And bear in mind, he is fighting giving the defense those same things. The defense is asking for all their emails, all their communications with their experts.
Right. All right. So then she took that like 20-minute break. I don't know what just happened here. Did you and I watch this together? What she said when she came back already?
No.
Okay.
It's provided.
Here we go. So she's walking in.
And it was 20 minutes. Is that how long she was gone?
About, yeah, almost 30, I think.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
That's what it sounds like. The defense and defense
so for
counsel.
that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
I mean, she's out of breath. She's like, and then she tells Alan he can appear on Zoom. So it's kind of like, yeah, you don't need to be here because I'm kicking you off the case.
Which is kind of bizarre because if they're having an evidentiary hearing where she's challenging something he said or done, I'm surprised that she would have him appear via Zoom.
Yeah. And somebody says a habeas petition was just filed by Karen Reed. I don't know. I have to refresh my docket. Does anybody have a copy of it? You can email it to me at fanbase@mlittlellaw.com. But what would that indicate to you, Allie, if a habeas petition was just filed?
I just don't know because they're obviously anticipating her taking some sort of action to remove them. But how could they file a habeas petition before she does it? So I'm asking if someone on our end can find that as well.
All right, let's take a look at some of these questions because maybe somebody has it in my email. Hold on.
His petition would be regarding the motion to dismiss based on the Supreme Court ruling, Dave.
So Bob says the habeas petition would be on the motion. He's guessing on the motion to dismiss based on the Supreme Court ruling. So it just could be timing that they're going to appeal.
Oh, here I got something in the Boston Herald. Thank you. Perfect. Let's take a look at this.
Appeal the Supreme Court saying that was not double jeopardy type thing.
All right, hang on one sec.
I wasn't sure they could take it up. I'm glad that they can. Interlocutorily.
Here we go. Karen Reed murder case. Reed files with feds to toss murder charge. This is just, thank you very much, you guys, you guys are always on top of it. Karen Reed has taken her double jeopardy challenge to toss the murder charge against her to federal court, filing a habeas corpus claim with the U.S. District Court in Boston. The federal filing comes on the same day Reed is at Norfolk Superior Court in Dedham for a motions hearing that was supposed to include her team's latest motion to dismiss the case. But no, because they haven't filed it yet. Instead, the hearing ended suddenly and dramatically with Judge Beverly Cannoni saying that the prosecution's presentation on behavior with witnesses in the last trial, quote, profoundly affects the defense team. Sides will reconvene on February 25th at 11 a.m.
All right. So tell me what, because I'm looking on the federal docket right now. What court is it?
U.S. District Court in Boston.
U.S. District Court in Boston. Region. What circuit is that? Do you know?
I don't know. I can look. Are you in Pacer?
Yeah.
Usually I just search by name and I pull it up that way. I don't even specify the court.
So Massachusetts.
Yeah, I would say Massachusetts.
They only have one. So
and you could do nationwide also. In the federal filing, Reed is asking the court to issue a writ of habeas corpus and rule that Ms. Reed's re-prosecution on counts 1 and 3 would violate her double jeopardy rights. I'm claiming that my April 2025 retrial violates my federal double jeopardy rights, Reed writes in the federal petition. Reed has filed the petition against Norfolk County Superior Court and the Massachusetts Attorney General. This comes after the Massachusetts Supreme Judicial Court issued a decision last week finding that Reed's pending retrial on the charges did not violate her rights against double jeopardy. Reed's attorneys have been arguing that several jurors reached out after last year's mistrial to say that they were only hung on count 2, which is the OUI manslaughter charge, and were ready to acquit on the other charges. They say that no other juror has disputed this claim and that to continue to try her on these charges would be double jeopardy. Re-prosecution is barred because there was no manifest necessity to declare a mistrial on counts which the jury was not deadlocked. Reed's federal petition reads, the jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution, the petition states. Both the Massachusetts trial court and Norfolk DA's office declined to comment on Tuesday. And then they go on to talk about what happened today at the hearing, motions hearing. At Norfolk Superior Court this morning, Reed's defense team and prosecutors from the Norfolk DA's office wrangled over some motions, but the day's schedule was curtailed following Special Prosecutor Hank Brennan's allegations about the defense not sharing the extent of their interactions with 2 of their expert witnesses in the previous trial, including an alleged payment of more than $23,000. First, Special Prosecutor Hank Brennan said he reached a deal to receive materials wanted from a Boston 25 interview with Reed's parents to be delivered by March 1st. Second, defense attorney Alan Jackson argued to be given a forensically sound copy of Canton PD, on and on and on. And then the other things, Mark Bederow. And then they talk about the things were you able to find it out?
No, I don't know why.
Prosecutors, all right. So then it just says this is a developing story. Let's go to some questions for a second.
It's telling me no results found. I don't know why.
Maybe they didn't.
It was filed today, right?
I think that's what they said. Yeah.
All right, let me clear this field.
Chloe Albert's Revenge. Thank you for your super chat. Anton, thank you for that. For your super chat. Rich Schiffer is here. Ducky Gate. Congratulations on getting your charges dismissed, Rich, and thank you for your super chat. Decline, thank you for your super chat. Kyle, another super chat from Kyle. Thank you. These are mostly comments. I'm just highlighting them. KR Dream Team, thank you very much. Kyle, again, thank you. Yeah, Misadventurous Book Mouse. And it's not ARCA I have a problem with. It's the feds hiring them that I have a problem with.
All right, so now I got a ton of stuff, but I got to find...
Thank you, B times C. Thank you, Edward. He's going to accuse them of an ethical violation just like he did Bederow. Crazy. That's what it seems like. Hard plastic and static mannequin, mint chocolate, poop flavor. Fairy Raven, this has made it clear the defense needs to go harder, play dirtier, because Brennan's going lower than Lally Proctor and the rest. Outrageous. Thanks, you. Thanks, Emma. Random thoughts. Thank you very much. M169, thank you very much. I was in Runkle's chat last night. Kyle, thank you so much for your compliment. I appreciate you. I am not related to Liza Little. Brenda Starr, thank you for your 20. Accreditation standards require impeccable record keeping. Canton PD and MSP should have their accreditation revoked. I'm outraged. Thank you. Thank you, Kyle. Again, 31 years with the fire department. I don't know, DFD, Dedham Fire Department. Thank you.
I can't find anything that was
filed today. No. Teacup Kraken, thanks for the 5. ARCA's contract expired July of 2024. I think you're right, because that wasn't an email. Thank you, Emma, for gifting a membership. How can Hank cry about a Rule 14 violation when the deadline hasn't passed? Well, this has to go, this goes back to the last trial is what I'm gathering from this. Thanks, David. Travis C says, man, Mark. Sharon, thanks for becoming a member. Edward, thank you for another super chat. Eddie Haskell Vibes says, Steph, thank you. Thank you, Roseanne, for your super sticker. Kyle for another one. Thank you. Guys, if I skip any, if I miss any, please forgive me. It's crazy today. Lady Zelda, thanks for the 5. The feds are watching, she says. Believe me, they're taking notes. Lady Zelda reads tarot cards. If you guys are into that kind of thing, go over and subscribe to her channel. Lady Zelda Kelly. She's awesome. Thanks, Cheech. Thank you on top. She was literally shaking. What motion was not covered that Alessi was supposed to argue today? There were a couple. So.
Yeah, I can't find anything.
Nothing in Pacer, huh?
I don't know if I'm doing something weird, but I did an advanced search with just her name.
Need to rewatch the opening with ARCA. All right, well, let's do that because I have that pulled up. Al, you got time or you want to jump?
Yeah, I got time.
Okay, let's see.
Oh, wait, somebody pulled, let's see.
Thank you, Edward. Thank you, Edward, again. He says, I think he's confusing before voir dire, after voir dire. It sounds like emails post voir dire. Right, but he also said he hadn't prepped with them. I don't know, Jen. I don't know what you can do, if anything. What, if anything, can Jen do to help? I don't know. Thank you, Gray Space. Somebody says that's for the coming trial, the 20 grand. And True Crime Eve, this sounds like an email after trial. So what? Well, let's listen. Let's pull up this Dr. Wolf. This is day 30, right? You guys said it was day 30. This is his actual testimony. I'm going to take it back to the beginning. Somebody said it was at 2 hours, but here's Dr. Wolf.
All right, Dr. Sheridan, you are all set, sir.
You're
Very
all.
well, thank you, Ron.
Thank you.
Thank you, Ron.
Okay, so this is June 24th, 2024, day 30 of trial.
This way, sir.
Thank you, Desert Quill.
Step right in and just watch the step for me.
Thanks, Tamara.
Can you stay in the face?
You tell us whether the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
It was one of the days the volume was good in court.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolf, last name spelled W-O-L-F-E.
Dr. Wolf, what do you do for a living?
I am the Director of Accident Reconstruction at a company known as ARCCA, A-R-C-C-A.
And what is ARCA exactly?
So ARCCA is a forensic engineering consulting firm. We have a variety of disciplines that include human factors, biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCA, correct?
That is correct.
What sort of contracts does ARCA routinely engage in?
147.52. I'm going to take your word for it, CH.
May I, Your Honor?
Yes, you
Thank
can
you.
move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction, is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency, not
At the time you did your
Exactly.
reporting, right?
So that is completely 100% accurate. And I might add the most important time that matters.
Right.
When they did when they came up with their conclusion.
Right. Right.
not connected in any way to the defense. Is that right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
Okay, you have not been paid by the defense.
I mean, that's what they said.
Right? So there's no date on that bill, so we don't know.
I have to say that there is no, you cannot convince me that these guys are all lying about this. You just
Right.
can't. So yeah, I'll need a date on the bill. If they're back billing for
Mhm.
stuff from before, I mean, that's weird. And I don't get it, but I just can't. It would be so much more of an issue to lie about it than to just admit they're getting paid.
Right, you have not paid us anything. Maybe did they submit a bill and they just hadn't paid it yet? I don't know.
That would be Weasley. That would
Right?
be
That would
not
be Weasley.
right.
I don't think he would risk that. I just don't think he would
I just
risk
don't
it.
think he would either.
And if he did, it wouldn't matter if he did, because quite frankly, based on the juror interview, did you watch any of that juror interview?
No,
The
Bob
jury
just told me about it.
disregarded the testimony of ARCA because they thought that they were either hired by Turtle Boy or Karen's car insurance company, so they didn't even give them any credit anyway. It would have been better for them if they did pay them, in my opinion, perhaps.
Right.
See what else?
And you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Well, I mean, was it
Right.
about his testing? I mean, again, this is like semantics. If they were in contact, he should have disclosed that, right?
Right. Yeah.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us in testify, correct?
That is correct.
Testing versus
Were you and
testimony.
your
Here, are we
team
splitting
asked to
hairs?
undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical
All
engineer.
right, so that's, I mean, that's pretty much the pertinent portion of that testimony. Thoughts?
I think that if he had in fact paid them, then this would be a very serious ethical issue.
Mm-hmm.
I just don't know that I would be floored. I would be shocked. That would just show such an extreme, like people have said, are the lawyers blinded? Are they biased? Are they this? Are they that? If that happened, well, then I guess it shows that. But I can't imagine he would have doubled down outside of the courthouse to say, no, we did not pay them. And again, as we keep saying, it's very normal to pay them.
Right.
It's abnormal to not have paid them anything. And the important part was, before you issued a conclusion in this case, we had not paid you. We had not, all of those things relative to that point,
Right. It's been clarified by Nick Rocco, says Jen, that the payment was for flights, cars, hotels, for them to come to voir dire and for actual testimony. So we didn't pay you to render your report.
Was that is that the words he spoke?
Yeah, let's.
That's what I was going to say. Did he parse his words and he kept it
right? Was he
relative to-
splitting? Was he like splitting hairs
Splitting
here? Let me
hairs,
see.
right.
Let's go back.
By the way, while you're doing that, I just got an order on the Richard Allen case, and the judge
Yeah.
denied without hearing the motion to correct errors.
Oh, surprising.
Not
Shocked.
at all.
The only other case that is even probably wackier than this one is the Richard Allen case. Delphi, for those of you who don't know. All right, here we go.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense. Is that right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
There you
Right,
go.
with
Never
the
met us,
report.
Didn't know who we were when you did that.
Right, when they did the analysis and the report and the testing.
Right.
Somebody's sending me like via email like links to a Facebook group post, but if I'm not in that Facebook group, I can't see it. So if Nick Rocco made a post and you want to screenshot it and email it to me, then I can access it. But otherwise I can't.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right.
Accurate.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything. No.
and you don't work for us.
That's correct.
You don't
As a
work
matter
for
of
us.
fact, I've never asked you specific questions about your testing before today.
That is correct.
About your testing before
Right.
today.
So, and this is voir dire, not trial, or
No,
this
this
trial?
is testimony. This is in front of the jury because this is on the 24th, I think, and the voir dire I think was on the 22nd.
All right. Well, that was a strange question, but obviously he wasn't trying to pull the wool over anybody. Everybody knows
Right.
he asked them during the voir dire.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides?
In terms of them reaching out?
Correct.
They didn't
Yes.
reach out. I mean, I don't know. He's saying we
And I
didn't
called
talk
you.
about your testing. So I don't know. Is this going to be like a semantics type thing, or is it just going to be that Brennan was misrepresenting everything and all of these emails came after the trial? I don't know.
Yeah. And it seems like I would have to say, it seems like they're trying to focus on the time that matters. But obviously, the way those questions came out, you have not been paid by. And I don't know, without us rewatching the whole cross, I would be surprised if on cross he didn't ask, well, the defense has paid you, you traveled, you stayed. Like, I can't imagine there were no questions like that.
Mm-hmm.
But, is that enough for her to remove his counsel of choice?
I mean, if she's looking for a reason.
And to delay trial for another, year or so? I mean, somebody needs to get up to speed.
I mean, they're not even going to come back. Is she telling Alan he needs to bring a lawyer with him to court? Hang on a second.
Oh,
Let's take a look. If this
certain.
This is Nick Rocco's post in, I guess, the Facebook group.
For those who don't know, who like me, who's Nick Rocco?
So he's the administrator of one of the Karen Reed Facebook groups, like Justice for John O'Keefe Facebook groups, and he is often a guest on Court TV. Like Vinnie Politan has him on as a spokesperson for the Reed case, and he does a lot of fundraising for the legal defense. And he says here, like Alan said to a reporter outside, they did not pay the ARCA expert to testify. What they did pay for was their flights, hotel stays, car rides, and things of that nature. Don't forget they had to be flown in twice. Hank is making it seem like the defense team paid them to testify, which is not the case.
So now that's saying they did not pay them for their in-court time,
Right.
just for their travel time.
Right.
So then that again is a fair, the testimony would be fair if that is accurate.
Right. Well, I guess we're going to find out more next Tuesday. Oh, here's a bill. Well, here's a bill to the DOJ. They paid ARCA $26,000. Somebody just sent me a purchase order from the DOJ. But I don't know what that has to do with this. This is the DOJ to ARCA. So let me just see. All right, somebody sent me the Pacer stuff. Hold on one second. But yeah, I can't cover those right now anyway. There's a lot of documents here.
Yeah, you'll have to do another live.
We could do another live stream later, after we regroup and have an opportunity to digest
all of this.
What is Bob
Bob
screaming
had
in the
said
background?
he actually had to get on another live, but he had said yesterday or whatever day that it came out that Bederow,
yeah.
That Bederow filed his a petition. They filed a petition for him to be admitted pro hoc, that they were going to claim that there was a conflict. And I was like, I don't really see a conflict. Like, we didn't really flesh it out fully. I'm like, I don't really see a conflict. But then based on what he said today, which, by the way, talk about double talk, the Commonwealth should not have any opinion on the chosen counsel of the defendant and the seriousness of her constitutional right to choose her own counsel. But by the way, I'm going to give you this opinion that tells you why you should not allow him in. And I think he did expand onto a way to kind of make it a conflict by saying it's in his other client's best interest that the witnesses be proven liars, and that's going to carry over. And then also how the witnesses are going to feel. And we know how she feels about that. That one might have legs, that it's going to make the witnesses feel uncomfortable. Now, she can make it where he can't cross-examine those witnesses. That that would rectify that. I mean, she could go as far, although I think it would raise constitutional issues, but to not have him in the courtroom if she was being
Right.
like, the way she gets
The way
extreme,
she did with
crazy.
the boy. Yeah, like you have to leave the courtroom when those witnesses are in the room.
Right. But
Um,
I don't think it should be enough to deny him his admission. I don't think that there's a
Because I
great
don't think
enough.
they have adverse interests. I don't think Karen Reed and Aidan Carney have adverse interests. And I think it's a waivable conflict. And I'm pretty sure Mark Bederow knows what he's doing. And that if he was going to step in to the Karen Reed defense, that he would get waivers from both clients and that he would speak to an ethics attorney and that he would make sure he might even go so far as to get an opinion from,
Right. I
the
just don't even know, like you said, they're not adverse. So I don't see where the actual conflict is that they would even need to waive. I kind of would have to probe Bob a little more for what he was thinking. But
Mhm.
if her issue is it's going to make the witnesses uncomfortable, then she can say he can't cross-examine those witnesses. There are
Yeah.
ways to allow her counsel of choice. I don't know, maybe you do, if they denied her Mr. Bederow, I don't know why I'm
Mhm.
doing that all of a sudden, that would be something that they would appeal. But sure as shit, if they try to take off Alan Jackson, that's turning
Oh, yeah.
into the
Yeah.
fight of a lifetime.
Oh, yeah.
She needs her. I mean, like, they did different things. They have different skills. They focused on different evidence. This is what, they tried to do, to just put a kink in the defense and then act like, don't tell me losing Alan Jackson's going to affect this trial. You have skilled lawyers. I'll give you Bederow. Don't worry about it.
No,
But
he's
no.
already tried the first case. Nobody knows this case inside out the way he does.
And you
his
need your
team.
other lawyer to not just know some things. You need all your lawyers to know everything. And it would take a second lawyer,
But would this disqualify the entire team?
I think she seems to be trying to go that way, but it's going to be a lot harder to exclude Yannetti. He's local. He's of record.
Right. But is she going to impute anything Alan Jackson did to the entire team?
It seems
and say,
she's going
listen,
to
you're all
try.
in trouble here, not just Alan.
Oh,
You're
no,
all in trouble.
It seems she's going to try. That seems evident. But I just noting it's a lot easier to get rid of Alan Jackson. Like, that's
Right.
simple.
But I mean, look at what happened in Delphi. I mean, they pulled those attorneys off and for no reason.
Right, but they weren't admitted through the grace of the court. And then if you
Oh.
violate a local rule or something like that, it makes it a lot easier than it is to pull Yannetti, because they don't have that little, like,
Right.
you've been, by the grace of this court, you've been allowed to step in here and speak when you're otherwise not allowed to. And now I've decided you're not worthy of this gift.
Yes, because it's a privilege to practice in Massachusetts, Mr. Jackson. She said that more than once, many, many, many times. I'm not going to freak out over this because I feel like maybe Hank Brennan, he misstates a lot of things, and there are a lot of things that he has misstated: testimony, facts, law, what happened in the previous trial. So this may be nothing, but it may be something important.
Do you think he was surprised it had the impact it had? Like, that he was like, oh shit?
Yeah, Hank Brennan. Yeah, he looked like he didn't expect this. He just thought he was, and then
That it was
there was
pounding
this
his.
like mic drop moment, the way he's pounding his fist, and he's like, oh, like, why did she have to take a break? Why did she need a timeout from that?
And that's the other
And
thing.
she didn't even give the defense a chance to respond.
No.
She didn't even let them get up and say anything.
No.
Like, wouldn't you have wanted? I would have wanted to defend myself, because maybe they could have clarified it. They could have said, oh yeah, well, this bill is for the upcoming trial, and
Right.
these emails were after. I don't
And it
know.
begs the question, why was she still so visibly or audibly shaken and out of breath? 30 minutes went by.
I know.
So that's not outrage at the moment that you're learning something. That's anticipation of what you're about to do next.
Yes.
All right. Well,
Thank you for coming. Are you going to jump off and go with Bob?
No, he's doing something with, he's got something he does on another guy's podcast
Okay.
every week, but I've got to run to a courthouse. I tried actually emailing the lawyer and saying, can we do this?
Go.
Can we do this meeting via Zoom? but she didn't
Because
answer.
I'm already at the
so-
computer. Thanks,
And I'm
sweetheart.
still in my pajamas.
I'll talk to you later. I hope you're going to
All
meet
right.
me in Vegas. All right.
Yes, I'll try. Bye, all.
Bye. Thanks, Allie.
Thanks.
Ali Mata. Everyone go to subscribe to Defense Diaries. They're awesome. Let me get through some more questions because we got a lot of them, you guys. More questions than answers today. Wow. Just wow. Duncan, Idaho says, I don't get all the attorneys who say, I understand why he said that, or I'd do the same thing, etc. How could you not say that Brennan is evil and a liar when he's clearly not acting in good faith? That is a great question and a great use of your super chat. I agree. Random thoughts. She did say it would have great effect on the defense, trying to stay positive. It could be a good thing. Maybe she got to wake up on the manipulative corruption in the Commonwealth. Maybe, but she did say not a great effect. In my opinion, it was like this is going to have a profound effect. I can't remember her exact words, but it didn't sound good. Although I don't know why she didn't let them get up and respond. Kind of like when she declared a mistrial and didn't give anybody the opportunity to see that note or to respond. So there's that. Deborah says it's just a ploy to get hold of something against the defense. Up until now, they've had nothing to justify a trial. Good point. Leah, surely this has to be after trial. I don't think Jackson would jeopardize his position. I don't think so either. Or his license, or his unethical violation. Coffee Cake thinks Brennan lied. Edward says, didn't hire them. I swear they talked about paying them for travel and hotel. That could be. Thank you, Edward. Brennan, master of misstatement, says Athena, who's also an attorney, according to her username. Thanks for your super chat. Marcello from Argentina says Hank lied to her face and then walked back and said that the defense provided that to him. This enrages her, but she doesn't care about Brady violations. I know. I can't reconcile that in my brain. I just can't. Thank you, Marcello. Meg, money was for travel expenses. The FBI doesn't pay them for travel, correct? Correct. And the FBI wouldn't pay them to testify at the trial either. Buzzing for Truth says sleazy, which is probably what everyone's thinking. Meg P became a member and then she gifted 10 memberships. Thank you, Meg P, for your kind and generous contribution to this channel. This is the most kind and generous group on the YouTubes. You guys are amazing and kind and generous, and I love you with all of my heart. Barbara Brady says, Jackson said they didn't hire them. Being paid wasn't mentioned at all. Well, we did see that, right? Didn't we just replay that and said they did not pay them anything? You have not paid us anything, is what Dr. Wolf said. The straining of credulity is here and says Brennan misrepresented. Thank you. I think that we might find that to be true. Jadzia says, I think AJ got them to confirm at the start of Direct that they were not engaged by the defense. Yes, we just rewatched that. I'm a little behind in the super chats. Katie says, read his file. Yes, the Boston Herald. Thank you. We went over that article. So thank you, Katie. We just looked at that. Could they have paid their travel expenses? Thank you. Yes, we think so. She's been looking for a reason to boot Jackson. Here it is, says Greg. Cedric Quill, this smacks of more financial abuse of Karen with these extra hearings, looking for an excuse to get rid of AJ. Brennan factually lied today. She's feigning outrage. I don't know. She was visibly shaken. It was odd. It was odd to see that. We haven't seen that since she failed to disqualify herself in the motion to recuse. Remember, she seemed a little out of breath that day, too. She ruled from the bench that day. That was a pre-trial motion, pre-first persecution. John Miller says, so Lally, his videos, and introduced inverted video trial. And this makes Bev mad. Why can't she say, Hank, turn over the video with the metadata? I'm outraged. I think we're all outraged. We have emojis for that, members. We have emojis. I am outraged. We are outraged. Right. Thank you, Brennan's proofreader. With misspellings in the name. I love it. Why didn't the defense get to respond to that? Exactly what I was saying before I even saw you super chat. Great minds think alike. Whatever clever. Why wouldn't she allow them to respond? Again, great minds. Impeach Canoni, says Dennis the Menace from Canada. Christine, could any payment to ARCA be for their travel and accommodations? That could be. Thanking me for my coverage. Thank you. Dream says, imagine Judge Bev's deflation when she determines that the information was provided by the defense, not the government. This was her gotcha. It makes me sick. But it was clarified, right? Like she had the opportunity to walk that back. And she didn't. She didn't. Melissa, can you please explain how she can get rid of Jackson? I don't understand. She should be mad at Brennan for withholding evidence. I agree. I agree. Brennan is not admitted pro hoc vice. Brennan also had, I mean, I want to see this motion to dismiss. I can't wait to see all the reasons why the case should be dismissed. But if like this is going to be a smokescreen to divert attention from what really is going on here with the Commonwealth having hid all of these videos until the 11th hour, until after trial, no metadata, we don't even need it. Like, that's insane. That's literally insane. Trial by ambush. Thank you, Edward. And says, I'd be asking for removal after that overreaction. Acting, she let her biases show out, and it was the state misleading her. Thank you for your super chat. Jojo says, no matter what, Bev is upset about, her theatrics are not appropriate. A judge is expected to stay objective and even-tempered. It was like she took a time out. Did she have to go take a phone call? Like, what was that all about? SP, thanks for the 10. I think she was outraged that the Commonwealth had documentation from the feds that the feds had not sent to her as well. Yeah, but she seemed to hold it against the defense, not the feds. So weird. Dream says they need to remove her again, or they need to make a motion to anyway, right? Fire on Assad, all for the people to the right. People to the right, the media. Exactly. Thank you. Elle says you don't need to be an ARCA expert to know more pedestrian versus vehicle accidents happen at night. I would agree with you. I would think that's, common sense, which a lot of people in this case seem to lack. Sage, look at Christina Rex's tweet. I think we did already. Thank you. Greg, what are the ramifications for Brennan if it turns out to be fabricated or misrepresented? I mean, it seems like he corrected it, and then she still went off on her little snit. Straining of credulity, Bev overreacted to Hank's misrepresentations. You might be right. That's what I'm starting to think. The more I think about this. Marie, yes. Didn't the Attorney General say both could talk to them? Yes, they could have. The Commonwealth could have spoken to them. They could have hired them. They could have called them in to testify. And quite frankly, if they wanted to get to the truth, they should have. They should have. But they didn't. It is crazy. It's backwards. Thank you, Fairy Raven Emma, for gifting a membership and for being with us all the way from Ireland. She jumped the gun, got upset over money that may have been paid, but didn't clarify. Yeah, and we don't even know if it was paid, and she didn't even give them a chance to respond. Forrest Dump says, Bev wants ARCA, maybe just Dr. Wolf and Jackson off the case. That's what this is about. They can still hire another accident reconstruction expert because any accident reconstruction expert is going to tell you that this was not a car accident. Nina, Bev said the defendant and the defense team, someone having a relationship with one of the crash daddies. I don't know about that. Sarah, is it because during the trial, the defense claimed they never talked to ARCA? I don't know. But now they've turned over the emails. So those were turned over by the defense and there's no date on them. So we still are in a state of confusion. As the old Genesis song, which is part of our Karen Reed playlist. Land of confusion. I'm sorry. This is a land of confusion. Shocking horror. Melanie, thoughts on this being a possible stunt to push the pro-Commonwealth media in an effort to kill the positive momentum from Karen's Ted Daniel interview? I didn't even think about that, Shocking horror. I didn't even think of that. What do you guys think about that? I haven't had an opportunity to really even look at any of the media spin or media reporting on the Ted Daniel interview. I thought it was very positive, but I don't know what the general consensus was. But thanks for your super chat. And says why she told AJ he can be on Zoom. Peace out. Don't show up again because I'm removing you. Haha. She didn't say you can take a red eye, Mr. Jackson. That girl, T, thanks for the 5. This is crazy, but I feel like it's a smokescreen. Will the defense get a chance to defend themselves? Yes. Next Tuesday, when I don't know if she's telling them you should show up with attorneys. I don't know. Because she sort of just ran out of there and cut that whole hearing short. Let's be realish, says just a theory, but the defense may know AJ is exposed, and that's why they brought Bederow on early. Ooh, I like your French spelling of Bederow. R-O-U-X. Thanks, let's be realish. I don't know. I don't think so, because I think each part of the defense team has a different skill set. Each attorney has a different skill set, and I do not think that the defense was expecting this today. I thought they were blindsided by it, and they're probably like, what the what? Edward says nothing against Karen Reed, but I don't think Jackson is lighting his reputation on fire, cheating for her to win. I don't know that he's cheating, Edward. Thank you, Pinky, for pointing that out to me. Thank you, Gonzo, for becoming a new member. David Reese, Dr. Wolf testified at the first trial about how lighting affects pedestrian strikes. Yes, he did. You're right. Thank you for the 5. Bev had the same shaky voice when denying the motion to recuse. Great minds, great minds. I didn't even see that before I said that, but yes, it's her tell when she's engaging in their games. Thank you, Schockenhora. Kelly says, am I wrong in thinking that the Commonwealth had access to these witnesses and if they wanted to, could have gotten the pedestrian usually hit at night info themselves? Yes. I feel so bad for Karen. Well, it's just more expense, more of all kinds of other things. I don't know. I see you says the bigger problem is that the jury was duped by not knowing who hired ARCA. That duping really worked for the Commonwealth. It did. It did, but they couldn't talk about the FBI having hired them. And then the jury was confused by it and said they really didn't give ARCA a lot of, or at least the one juror that Turtle Boy interviewed named Ronnie said, they really didn't credit ARCA with a whole lot of, didn't find them to be 100% credible because they didn't know who hired them. They thought it might be Turtle Boy. They thought it might be the Karen's insurance company. They thought it was just a, quote, distractor, which is weird terminology, but weird. Amy says, someone I watched, Laura, you know's dad said maybe the FBI would not pay the travel fees. So either defense paid that or ARCA did it for free. I think that's what the bill was. And that is Nick Rocco, the spokesperson, said they didn't pay them to testify. What they paid for was their flights, hotel stays, car rides, I'm sure meals, because they had to come in twice. Remember, they had to come in for the voir dire and then they had to come back to testify. And I don't remember where they're from, but wherever it is, they had to fly them to Boston last minute. And that's expensive. Gray Space, Hank thinks he's the protagonist. I mean, he really, like, that was his mic drop, stomping fist on the podium moment. Thanks, Amanda, for your super sticker. Habeas petition. Thank you, Meg. We reviewed it. What we could get of it. J.O. wasn't hit by a car, so why does the statement matter? Great point. Meg, thank you to Law Furio for the info. Yes, we read it. We read the Boston Herald article. If you weren't here, go back and rewind. I'm late. It's on my live feed. Oh, you picked my timestamp. Thanks, Pinky. But I think we found it. Thank you, Pinky, for all your super chats to get me that information. I appreciate you. Brennan ran out off the courtroom to meet up with, apparently, I don't know about that. I cannot confirm or deny, J9. Thanks for your super chat. Craig says a bill is not a payment. Thank you so much for pointing out the obvious. So many of you can find the words when I just can't because there's so much stuff swimming in my head and I'm so outraged. You're right, Craig Tracy, a bill is not a payment. In Jackson's email, he agrees to pay and then ARCA calls it off because still contracted by the feds, nothing burger. There you go. There you go. Perhaps ARCA sent Jackson a bill and then they found out from the feds, oh, we're still under contract with the feds, so you can't pay us anything. And ARCA calls it off. And so perhaps in true Hank Brennan fashion, he only read portions of the pertinent emails and not the pertinent portions of the emails. Thank you, Craig, for your super chat. Kelly became a member. Or no, Kelly's been here for 3 months. Thanks, Kelly. Sinbad, a blind man, could tell this is a serious cover-up. Comes a time when the blind man takes your hand, says, don't you see? It's one of the best Grateful Dead songs out there. Mo, couldn't she have just let Jackson respond? She could have. Sounded like she didn't want to let him. Hannah became a member. Welcome, Hannah. Think you're going to like it here. Cher Kalaki. I emailed the USDC document. I can't. They're zipped and I can't unzip them. Chloe Albert's revenge. Thanks for the 5. If Bev wandered into a corn maze and got lost, I would not be mad. Well done. Well done. Alicia says AJ is a strategist. He doesn't need to cheat. Right. You're right. JSMP Jen says desperate times, desperate measures. Deja Vu trial 2. Well done with the username. This has me so nervous knowing how Bev reacts to the defense. We'll see. We'll see if Hank Brennan just misstated facts in open court. Would that shock you? Would it surprise you? It's upsetting to me that I can't call Bederow and get him on here to talk to us about this, but We had Allie, so that was great. Allie Mata. Sometimes when I'm sitting here by myself, I'm like, am I crazy? Am I crazy? This is crazy. Am I crazy? Am I being gaslit? And it's so nice to have another attorney here telling me I'm not being gaslit. So thanks, Allie, for coming on. Thank God for you and Allie's commentary, says Alessi's middle finger. Kathleen, if the outline questions were based on the report, which was available to both sides, would that be discoverable? It should be. It should be turned over if they had communications, yes. Because we've seen in some recent discovery demands where they want all communications between the experts and the Commonwealth. So yeah, that is something discoverable. Thank you, Kathleen, for the 10. Greg says, Brennan doesn't care whether Karen Reed is innocent or guilty. Brennan only cares about taking down a trophy lawyer. Alan Jackson, nothing more. Thank you, Greg, for your 10 and for your opinion. You might be onto something. Jerry, if it comes out the judge was misled, what happens? Well, she'll get mad. She'll get mad. And this was calling off of a hearing for nothing. Does Massachusetts do Frank's hearings? They do. I don't think they call them Frank's hearings, but I'm not sure what they call them. I can't say that I'm 100% on my Massachusetts procedure and rules of court, but they should. Roseanne, Melanie, you're so smart. Wish you could join the dream team. That's okay. I'm perfectly happy sitting right here in my chair and screaming at you and with you and to you and for you. It's okay. I am so happy where I am. I can imagine what they're going through in court right now, like the aggravation, the agita. And plus, I have a really great commute to my studio. So I'm happy here. Thank you, though. Good citizen. Do you think Bev is still worried that it's under investigation by the feds versus Brennan's where it's out? I don't know. I mean, that reaction was a little out of place, right? It just seemed to be a little bit of an overreaction. Why couldn't Jackson respond? Dog lover? I know. I have the same question. Can Hank get in trouble for this? When, not if, he misrepresented where the emails came from, but he did correct himself, which is why I don't understand. Srini of credulity, thank you for your 50. On what grounds can she boot Jackson? She could say that he is in violation of Massachusetts court rules, and it is a privilege to practice in Massachusetts, Mr. Jackson, and therefore I find you in violation of the court rules of the state of Massachusetts, and therefore I'm going to revoke your pro hoc vice status because it's a privilege to practice here. That is a possibility. Does it have any merit? I don't know, because I need more information. I don't know the dates of those emails. I don't know the date of that bill. I don't know if that bill was paid. There's so many things we don't know. Spanky walked it back to the defense that handed it over, right? Right. But when she went back there, we don't know what happened when she went back into chambers. We don't know what happened. Right? Did she get on the phone with someone? Did she talk to the feds? We have no idea. Great question. Thank you so much for your super generous super chat. Michael says, I think this is a stunt because Hankey's scared of the upcoming motion to dismiss for gross prosecutorial misconduct. Well, that's a great point too, Michael. Michael Martin coming in with a hot take. That could be. I can't even pronounce your name, but it's KYWYMY. Thanks for the 5. Seems we've got a $25,000 upcoming ARCA travel expense to pay for the upcoming trial. Brennan's practicing a Darvo strategy. If you know, you know. She didn't let him respond because that's how Massachusetts does things, says Amor of Alessi. Trial by combat with AJ and Hank, says JSMP Jen. Thank you so much for your super chat. I got to close some of these tabs because I am like, I don't know. I keep getting the aw snap. Do you guys get the aw snap thing on your computer ever? And I think it's because I'm running out of memory and I don't really know how to fix it. Stormy Storm's life. Anyway, Brennan could get in trouble for lying to Auntie Bev and stating things incorrectly. Could be. But again, we don't know what happened when she went backstage. Backstage. We don't know what happened. Who she spoke to. What she inquired about. We don't know. Does Brennan get in trouble for anything? Ever? Like never turning over video, not having metadata, thinking that he's personally offended that they even asked for metadata? Like what? Amber says, very convenient that Brennan failed to provide an affidavit with all these claims just to hit defense with a fake gotcha. Yeah. And there's still motions they didn't get to today. So, you know. Michael, there was a blue light sale on White Claws. Very funny, Michael. Very funny. GV, Brennan already made Dr. Russell mad. What about professional witnesses when he's accusing them of perjury, including with the defense? Yeah. Hannah gifted a membership. Thank you, Hannah. Barbara Brady says I was wrong. I posted it a while back. I'm not sure what you're referring to, but thank you. Adam Lally resignation. Is this what Peggy and Paul were grinning through the entire hearing? Is this why? That they knew Hank was going to come out with this? I don't know. I don't know. That's interesting. I'll have to go back and watch it again. I didn't notice they were grinning because I was focusing on you guys in the chat. Mrs. Bouquet with the super sticker. Thank you, sweetheart. She rage knits, and we have a rage crochet club here as well. Why are there invoices from ARCA to the defense, according to Brennan, and to the DOJ for the same amount? That I do not know. I think she said that one was 26,950 or 925. And then the one that somebody emailed me was a different amount. So I don't know. Maybe they sent it to the defense firm and then they were still under contract with the feds. So they had to send, I don't know. I can't speculate. I'm sorry. Connie so fancy if Hanky misrepresented the payment by the defense, can he be sanctioned for his accusation and delay? Well, he could technically, because he could, but will he? I think is the better question. Thanks, Connie. I agree with Allie. Bev was excited, says Emma. Semper Fi, U.S. Marine Corps cowgirl. Is the email date with the 42 minutes of video and all the ring footage on the island of Misfit Toys? I think so. I think so. I would love to see you and Nan together. Thank you, Megan Johnson. Thank you so much for your super chat. We'll see. I can barely skip to my own shows. Having a guest is so hard. It was like Allie was texting me. She's like, can I jump in? Give me the thing. I need to come on. So that's how that worked out. Spontaneity. Sheila, could Babe have time? Could Babe, I think he meant Judge Canoni, have time to call the FBI and clarify? She could have. She could have called the feds. She could have called the DOJ. I don't know. Sheila, that's a good point. That's what I'm saying. We don't know what happened back there. Meeple Marcy, Sketty Stain. I don't think Bev wants to get rid of Dr. Wolf. She needed a bib to catch the drool when he came to court last trial. And then it was so crazy because Brennan was like, I don't care if they testify. I'm fine with them testifying. Jerry Roth became a member. Welcome, Jerry. Kelly Jane says, so AJ sent emails with all this info, barring send date. And who sends such short emails? I was a bit early before when I put, yeah, but also what was odd about that was like, it sounded like a conversation, almost like a text conversation, right? And not like emails responding to each other. So yes, I thought that was very, very strange. Thank you, Lisa, for the Venmo who says, after what has transpired today, have a bottle of wine on me. Thank you, Lisa, for your Venmo. I appreciate you so much. Jennifer says, thanks. Great show today. I'm still watching. Thank you. Thank you, Jenna127. Very kind and generous, as always, of you guys coming in. Lucian Gonzo, thank you for the 5. Thank you for the 5, Gonzo. This is wild. What a wild, wild day. It's crazy. You guys sent me the count 2 verdict slip, which is great. We'll save that for a future show because there's so much more that has been just provided to me that we can cover, but I don't think we can do it during this stream because we've already been here for like 4 hours and there's so much more that we need to get to. Hang on. Samantha, thank you for the memo. Says, I want to say so many things in your chat, but I'm working to refrain. I suspect many of my thoughts are similar to yours. Thanks for coverage of this hearing. I appreciate you so much. Sarah, thank you so much. Says, OMG, who's he defending? Brennan is ridiculous. I am so mad at the man. Thank you so very much. I think we're all mad at the man. Colleen says, is thanking me for sharing my knowledge of the law. Thank you so much. I appreciate you. I mean, we have these other motions that we can go over now. That's going to be fodder for a separate stream because now a whole wrench has been thrown into this because they have to come back next Tuesday. What did they say, at 11 a.m.? 2:25 at 11 a.m. Allison, thank you so much. Says, thanks for everything. If the trial does start April 1st, I guess they're all in on the same joke. They're all in on the same joke. You ain't kidding, sis. You ain't kidding. And Justin Green, as always, thank you. Oh, says it's freezing outside, but we'll be warming up inside the Superior Court in Dedham. Oh, yeah. Were you there today, Justin? Justin, were you there? So many things and stuff that we need to review. Piney Woods says it was wholly unprofessional of Bev to stop the hearing without hearing from the defense. She really needs to recuse. And it was wild what she said. Like, this has grave ramifications for the defense and defense attorneys. Life According to Martin says, if there's no chain of custody, then surely the case should be booted. Yes, and I'm sure that that is going to be part of the motion to dismiss for egregious governmental misconduct. However, we seem to not even be able to even get to that because with every hearing, as Harmony says, with every hearing, motion, etc., this case gets more and more and more wild. Gets more and more. It's insanity. I need to digest this a little bit. So what I'm going to do is go digest this a little bit. You're going to want to make sure you hit subscribe because it's free. And make sure you hit the notification bell for all notifications. And make sure you have it set to all notifications. And make sure your phone is set to all notifications so you can get the notifications when I do go live, which is also often on the spur of the moment. And so you never, ever know what's going to happen around here. Cupcake Nation. Can't make everyone happy. I'm not a cupcake. That's where that comes from. There's a sign back there. I have 5 kids. They're never all happy at the same time. Scott McGinnis was out there today. He says, it was cold out there, lots of wind, made flag and sign holding difficult, especially with numb fingers from the cold. Well, you're going to have to rewind, Scott, and go watch what happened because it was what? Oh, Mama She, thank you so very much. Mama She sent me $100 for a bottle of wine. You're amazing. You guys are awesome and so very, very, very kind and generous to me. And you're so kind to me. And I appreciate you all so very, very, very much, more than you know, because I've been screaming at this for a long time. And I know that you guys have also been screaming about it too. And now we can scream about it together. Thank you, Mama She. I appreciate you. I may be back later. You never, ever, ever know. That's why you're going to want to be apprised. Thank you, moderators, for keeping it classy today. We had over 10,000 people in here for most of the stream. And so this was a hard one. I even had to put it on slow mode, which I usually do not do. So thank you, Scott Messersmith, Scott, Team Brittany, Lil Cupcake, and all my other moderators that were here today. You guys are the bomb, and you know it. This is wild. I need to go get some other information, and then maybe we have to come back and talk about this later and scream some more. So thank you. Judge Bev did ask Brennan for the copies he had at the end of court. Okay, thank you, Sheila. Thank you. I'm going to have to go back, and thank you, Lil Cupcake. I love you with all of my heart. All right, you guys. Stay cool, stay kind, stay classy. Do the YouTube things. Smash the like, comment respectfully. Tell me what you thought is going on. Tell me, email me. My email's in the show notes. And my God, I gotta digest. I gotta digest. This is wild and crazy. It's wild and crazy. It's like Steve Martin and Martin Short. Were they the wild and crazy guys? I don't remember, but yeah, I may have to come back today because I may not be done with my outrage. So let me go regroup. I'll see you guys real soon. Peace.